Right. Right now, our family is going through so much.
Our name is application.
That's
What's the name? Check for you.
Yeah, I was curious myself. Because man, feel like this case, I want
CANO.
that's the last name, yeah, first name to recall.
Ricardo.
He played a while back, he's been sentenced for the
Morning.
institution and
See it on the calendar for today. I see your motion. Also from my. Yeah, I mean, that's what I see in the document, motion to modify conditions and services. I didn't.
tell them wrong calendar.
Good morning, Ms. Watson. Can you hear us?
Sorry, yes, I can hear you.
Great. I will let you know when we need to get on the record. We'll do some calendar calling and basic discussing, but when I need something on the record, I will make that clear.
Okay, sounds good. Thank you.
You're welcome. Okay, good morning, everyone. Schedule-wise, we've got a bunch packed into the morning. We'll see what we can get done. It may spill over a little bit into the afternoon. We have a few variables depending on who walks through the doors of the courtroom. We have a hearing that was going to start at 9. That's the Okoro matter. Ms. Williams is here.
I am.
Are your witnesses here?
Yes, Your Honor. They are here. One is currently in the building and 2 are just now being dropped off. So
Okay.
we're in good shape.
Got it. Well, we obviously need Mr. Okoro and his lawyer or lawyers. So we'll hold on that. We do have someone in theory joining us from the Department of Corrections. I don't see that online yet, so we'll hold off on that. And then we've got a calendar that has a few revocations and a mishmash of other things. And we'll try to knock those out when we take breaks from the Okoro matter. We have it's pro se, but I think I heard you, Mr. Ford, referencing Mr. Cano as well. He had filed a motion on his own. Did you represented him back when he pled?
Correct.
Right. So if he shows up when you're here, you can bend his ear. His motion is well pled. He just doesn't want to be paying restitution if the victim in the case received an insurance settlement. And so we just need to get to the bottom of that. And because I was familiar with the case, we tried to wedge it in to today when we're trying to wrap up everything we can.
Judge McBurney, if I may, I'm here, I'm present. I wasn't able to make it, and I do apologize. I wasn't able to make it in person, but I did present myself through Zoom. I spoke to Ms. Nelson, and she said that I could join the Zoom meeting.
Great. If you could relabel yourself with your name instead of iPad 7,
Okay.
that'll help me. And we'll see if we can tackle that this morning. Okay?
Perfect. I'll get on there right now. Thank you, sir.
Okay. Let's see what else we've got on the calendar. And I guess, Ms. Wood, if it's a public defender matter, you or Mr. Cobb will be handling it? Great. Okay. And Deputy Gordon said everyone was, anyone not here today? Everybody's here. Perfect attendance. Well, let's at least get a sense of what we're doing with each of the cases. Travis Christian, who I guess was the Judge Downs case. It's an old, either way, it's here. I signed the warrant last year, about a year ago.
This was Miss Rios, but I think he has a permanent attorney. That's the attorney that appeared in one of our drug court hearings.
Okay.
I'm not exactly sure. She knew that we did a hearing today.
Okay. Well, we'll hold on that. So Ms. Clark, that's the correct name.
No, is not attorney.
Okay. but Mr. Christian has a private attorney. All right.
Gotta be. I don't know who it is.
Randy Manuel.
Hey, good morning, Your Honor.
Good morning.
Spoke with Mr. Manuel. We are requesting a reset. There was a bit of confusion. He was supposed to retain a private attorney. His family worked on it. They couldn't get the raise. So now I went over to the jail Friday and did the initial interview. We could please have the matter reset. And
Sure.
we also, at a later date, wanted to speak with the court about an order for a mental evaluation.
Okay, so I'm happy to reset it. This means Judge Ellerby will be handling it. There's no reason she can't do all the things you're interested in talking to her about. I just didn't want you to be surprised, like, wait, why are you dragging me to a different courtroom? Do you need me to say any of this to Mr. Manuel, or he's in a good space?
That would be appreciative because I do believe he has family members at the today.
Okay, great. And you are connected to Mr. Manuel how?
Yes, sir. I'm here for proceedings.
Okay, great. Well, I'm gonna explain to him the situation. And so you know, he will come back soon. The defense is wisely asking for a little more time because it sounds like the public defender will be keeping his case. Mr. Manuel wasn't able to hire private counsel. And so they want a little time to work with him and make sure he's in a good space. That request for a potential evaluation means there may be a little concern that Mr. Manuel's having a little trouble adjusting to what's happening. So I'll just explain that to him in a second, and then we'll get it reset for Judge Ellerby. And Wakilia Tucker, I remember her.
Yes, Judge, so she's mine.
Yeah.
We had reset this for program went, and Ms. Tucker told him she was not interested. So I need to speak with her. I have a feeling we can do this non-negotiated today. It won't take
Okay.
long.
All right. Robert Davis.
Yes, Your Honor, I just spoke with Mr. Davis back in the holding tank. He was able to get conferred the offer from the state, and he will accept. And the offer is 5 years probation to serve 6 months with the balance probated, and he's willing to take that plea today.
So Davis will be a plea.
Yes.
Okay. Barry Wells. Huh. I don't know. Why did this come back here? Ooh.
He sent it.
That Judge Richardson.
Judge, yeah, so this is the one, we sent it over there to handle a revocation and a new case, and it bumped back to us.
Yeah.
I met with him last week. I'm asking, well, I've already filed the waiver, so we'll do the arraignment. There's some confusion about his participation in drug court, so I'm gonna have to sort that out. It sounds like he was in drug court at one point.
I'm pretty sure he was terminated from drug court. Yeah.
So I believe that he has some confusion about his participation.
Okay. I mean, I can unconfuse him on that because we gave him several opportunities.
Yes, from the docket, that is what it looked like for me
Yeah.
as well, Judge. But I already explained to him that we'll just do the waiver today.
Okay. All right. Melvin Rigby.
This is also my client, Judge. I've already filed the waiver. We'll enter a not guilty plea today.
Okay. And conveniently, we have Ms. Williams here. Ricky Pierce.
I think he's handling this case for himself.
That's how he rolls.
I know Ms. Rios did speak with him though.
Okay.
Or not.
I may just bump that one to Judge Ellerby.
Yes, sir.
Okay. Happy birthday. Her birthday is on Wednesday, so it'll be a birthday present. Thomas Smith is a plea. And I saw Ms. Kim. There she is. Hey.
That'll be negotiated for your consideration.
Okay. Are you here also for Mr. Okoro, or will Mr. King be handling that?
I don't know if he's on, but I'll be here for that one. Judge, if I could speak to the state briefly on that one.
On the Okoro matter?
Oral matter.
Sure.
Present as well. And Judge, I also have another one, Corey Gross, for revocation.
Ms. Nelson said she didn't put him on its own.
That's the add-on. Okay. Okay. I'm sure it's on. We have a catch-all today is what we call it. Yes, walk-in probation warrant, Corey Gross. That's you.
Yes, sir.
Okay. I'll make sure we get that to, where's my This will be my running list. Gross. All right, so 3 matters with you. And then finally, Maurice Floyd. Think he needed to be here?
Yes, Shada. It's my understanding he hired Jennifer Hansen for this matter.
Hmm.
I actually spoke with her recently. I thought she was gonna go on Zoom. But yes,
Judge, I
Okay.
believe the attorney filed a waiver. It's Jennifer Hansen.
Yeah, okay. Did you, excuse her and her client?
I excused her. I'll have
Okay.
to go back to my email and check about the defendant.
Well, but if you excused her, my bet is she told Mr. Floyd he didn't need to be here. She's done a waiver and an entry, so we'll just do a scheduling order on this one. Okay, thank you. All right, so, let's look up. Let's see. Yeah, I don't have an entry in position 1, but we'll see if someone shows up for that. So why don't we get Mr. Manuel to the door? That way we can be done with that one. And was there anyone in court who thought they had a case and didn't hear that case call? Nope, okay, we got a good, yes.
Yes, sir. I'm trying to work on here for Ms. Dickens. You'll place on the calendar for this morning.
Yeah, I'm not seeing her.
Yes, Your Honor, and she's coming,
She'll be here. Okay, I hope so. Did she make it to Florida?
Yes, Your Honor.
Good, okay. We'll talk when she gets here.
Your Honor, would you prefer if Ms. Kim and I step outside?
Yeah, why don't you do that, and then we'll knock out something with Mr. Cobb or Ms. Wood and Ms. Smith, and that way, if you, thank you, that'd be a great use of time. Good morning, Ms. Shigley. Good morning, Mr. Manuel.
That's it. What's going on?
How you doing?
Fine.
Good. I just wanted to give you an update of what's going on with your case. Mr. Cobb explained to me that at one point you were thinking about maybe hiring a lawyer, but financially that wasn't working out. Is that correct?
Yeah.
So you're going to have the very capable public defender's office representing you for a revocation. And that's all this is a revocation. I signed, actually some other judge signed in April of last year, an order that flagged a few things that you had been doing that were inconsistent with your probation. So we need to work through that. You need a lawyer. Mr. Cobb is standing right next to you, so he'll be handling things for you. But because now you are saying, I need the help of the public defender's office, they're asking for a little more time to work with you and see what kind of services they can line up, make sure you're doing okay before they go forward with the revocation. Because a revocation can have some pretty serious consequences. The state could ask for you to be revoked and sent into the prison system. I don't know what the state's going to recommend, but we're not going to do that hearing today. I just wanted to bring you out here so you know why you were brought over. And now that I learned more from Mr. Cobb about the shift in representation, I'm going to grant his request to give you a little more time so the two of you can work together and Mr. Cobb can let the court know what the next steps are, okay?
Okay.
You'll work with him when he comes to visit?
Yeah.
Good. All right. Any questions?
No.
Okay. Well, a judge will see you soon.
All right.
Thank you. And I want to make sure you saw you have a friend here.
Yeah.
Good. All right.
Thank you. All right.
Ms. Smith, are you in a position to talk about Mr. Cano's case? Did that hit your radar that we'd be talking about it?
It did not, I'm not too familiar with the case.
Okay, well, let me ask Mr. Cano a few questions and we'll see if you need to do a little research about it. He filed a pro se motion. He and one other defendant, pled guilty to, I'm gonna call it a bar fight. And the victim, I don't remember if it was a broken jaw, but whatever happened to him was significant enough, one, that it was a felony, and two, the medical bills were big. And Mr. Cano and his co-defendant were jointly and severally liable for these large medical bills. Mr. Cano has reason to believe, I'm gonna let him talk to us about this, that the victim got an insurance settlement. And so Mr. Cano is leery of double recovery. Probably his view is more, why am I paying if he's already been reimbursed? But he's correct. If it was 100 grand and the victim got 80 grand, I'm making the numbers up, from the insurance company, then the joint and several liability for Mr. Cano and co-defendant would be 20 and not 100. So I don't know, he may have some paperwork. It may be your office needs to reach out to the victim to see what you can find out. Mr. Cano, why don't you get us up to speed about what you've learned? And we may have to reset this so that Ms. Smith can do a little research. Can you give me, do you have the case number?
Yes, give me 1 second. I have it right here. The case number is 22 S as in Sam, C as in Charlie, 180840.
All right. John Lee Johnson and Ricardo Cano. All right. And you got a first offender disposition in October 2022.
Yes, sir.
5 years probation and restitution of $41,000 to Mr. Cataldo. That's the victim in the case.
Yes, sir.
So, and you got to stay away from the tavern.
Yeah.
So what makes you think that Mr. Cataldo has already been made whole or partially whole?
Well, so I was right after my plea, I was contacted by the attorneys for the tavern, and I was actually part of a almost 3-hour deposition over the phone with the North River Tavern's attorneys and Mr. Cataldo's attorneys. And they did confirm that they settled. I don't have a number. They weren't able to give that to me. But I do know that they settled. And I know from the beginning of the case, I had 2 plea hearings. One of them was there in person. The other one was through Zoom. And on both of those hearings, Judge McBurney, you did bring up the double recovery. The first time in person, we brought up the fact that he had received some grants and some aids to pay for those medical bills. And I remember you said that with his attorneys, they had to come up with a number of what he paid out of pocket, minus, everything that was aid for him. And that was going to be the final amount. Ever since I've been on probation, I've been trying to find out what happened with those final numbers. But nothing was ever resolved. So it was kept at the original amount. And then now that I know that there was a settlement with North River Tavern, I've pretty much done everything how it was stated in my first offender plea. Haven't gotten in trouble or anything. And I know that the only thing that is keeping me, because you said it was 5 years with a possibility of minimum 3, as long as I paid for the full restitution. And I know that if he got made whole, that's pretty much the only thing that's possibly keeping me in probation. So that's where the motion came.
Okay, got it. Ms. Smith, how much time would you like to have your victim advocate try to contact Mr. Cataldo to see where he is financially? Hey, are you Mr. Cataldo?
Yes.
My gosh, how'd you know to be here?
I was contacted by the.
Well, all right, good morning.
Just wanted to say you're here.
Okay, we didn't mean to, unfortunately, we only said nice things about you. How are you doing?
Not well. If you don't know.
Why, yeah, I do, that's why I asked.
Yeah, I've been struggling ever since. I
I used to sort of been shifting over, and I've had continuing ongoing medical bills that haven't stopped.
Okay. So you don't need to disclose anything in this setting, but I am going to ask you to speak with Ms. Smith, who has replaced, you probably worked with a different ADA back when this plea happened, but they rotate around in the district attorney's office a little bit. It sounds like there was a settlement with the tavern. Okay. Well, if you don't mind, and you don't need to do it right now, but if you leave your contact information with Ms. Smith, I think she will want to talk with you about what financial support you've been able to receive through insurance, through settlements, et cetera. And then she'd be in a better position to let a judge know what that situation looks like vis-a-vis Mr. Cano's obligations as part of his sentence. I see that he's paid some restitution. It hasn't added up to half or all of the 41,000, but he is paying as able. Probation is working with him, and if he won the lottery, you'd see more. If he's working hard but not earning a lot, then you see less, because we don't take food off his table. But if he's eyeing that new Porsche, he doesn't get the new Porsche. He takes care of his obligations to you, and he's been doing that. So if you wouldn't mind getting your contact information to Ms. Smith, someone from her office will want to talk with you, and then we can close the loop at a subsequent hearing. Is that all right? Okay. Mr. Cano, you may not have been able to hear everything Mr. Cataldo was saying. He's here. He was in the back of the courtroom. He explained that he is receiving ongoing medical care for the injury to his jaw. He's going to meet with the district attorney's office. They will develop a more complete financial picture of what's going on. I think what we'll do is reset this so that you and the state can have a conversation about whether Mr. Cataldo's been made as whole financially as he can through your side and Mr. Johnson's side, or if this is an obligation that's going to require you to do the full 5 years of probation rather than just 3 years. I assume the contact information that, well, let me make sure what's that I want to assume. In the system, we have an address for you, Mr. Cano, that is, well, there are two. One is in LJ. Is that where you are now?
Yes, sir. I had spoken to Ms. Nelson when I was setting up the hearing, and she was able to do the change of address form, and everything else should still be the same in the system. Yes, sir.
Okay, then we're all set. You will get notice at that address when this is reset. It's going to be a different judge. I don't know that judge's view on Zoom appearances, but you can call chambers there and say, look, I'm up in LJ. Is it all right if I Zoom in? And if the answer is yes, then this works. If the answer is no, then fill up your gas tank, and someone will see you down here in Fulton County.
Sure.
Okay. Any questions?
No, sir.
All right. Mr. Cataldo, any questions? Okay. If you don't mind sticking around, I'm going to have Ms. Smith get that information from you right now. We'll figure out what we're doing next. Okay. Thanks. You're good to go, Mr. Cano.
Thank you, sir. Have a great day.
Mr. Ford, before you go, do you have odds on whether your client? Okay. All right. It was good seeing you. It's a little warm for a three-piece today.
It was what it is. I'll be back in 11.
Okay. All right. I'll be here.
It's optimistic.
Okay. Ms. Williams is outside again, so we'll hold off on the Okoro matter for another moment. Ms. Wood, Mr. Cobb, anything else we can do with no prosecutor? We have Ms. Nix here.
I put 9 o'clock on my calendar and didn't realize both my cases were 11.
Well, we could knock one out right now if it's knockoutable. And Judge Ingram, intern, if you want to be in the jury box, you're welcome to be in the jury box. Up to you.
Ms. Kim's plea.
You can be right there too, if that's better.
I think he was excused. Floyd was excused, right then?
Yes, Jennifer Hansen filed a waiver and an entry. So we've got counsel and a waiver. So we'll do I don't know I don't know the handoff with Judge Ellerby, if we'll do the scheduling order or if she'll just be told. But Floyd's taken care of.
Okay, well then let me check on the plea, see if the victim is gonna be here or not.
That's the Thomas Smith case? Okay.
I don't know, I don't see notes that she is gonna be here, so let me check with the victim advocate.
Okay.
If she's not interested in being here. so
Okay.
we'll do it.
All right, I still don't see Department of Corrections. Anything else? Do we want to arraign anyone or?
We can do Mr. Wells if he needs to be brought to the door.
Okay,
This is shown by.
yep.
Judge, the Department of Corrections is scheduled for 10.
Okay, thank you.
And Judge, whenever they do get online, I'm gonna hop on the Zoom. I need to just talk to Mr. Greer for like 2 minutes.
Okay,
Hopefully it'll be during this.
he's not on, so he's on my special list. All right, Greer. Any update on Ms. Dickens? Oh, she's here. Excellent. All right. Good morning, Mr. Wells.
Are you doing good?
I'm all right. Good to see you. Sorry to see you dressed like that. I had been hopeful that when you were with Judge Richardson on your revocation, this case would be resolved as well. Don't know what happened there, but Judge Richardson said that the shoplifting case was coming back here. So it is back with me. You're going to feel a little bit bumped around, and I apologize on behalf of the courts, but effective Wednesday, all my criminal cases are going to a different judge, 2 doors down. What Ms. Wood said she was going to do today was waive arraignment on your behalf. In other words, enter a plea of not guilty. We'll get a scheduling order entered. But this is a case that's going to need to move along like a new criminal case would, because Judge Richardson didn't resolve it in connection with your revocation. Yes?
You know the reason why she terminated probation, right?
I don't.
Because I wasn't in drug.
Well,
Drug court in April 2023. So all the time I've been doing, it's been false imprisonment. I'm trying to tell y'all that.
Okay, I'm pretty confident that you have not been falsely imprisoned, given all that's been going on in your life. But drug court's done, so we don't need to worry about drug court. Judge Richardson's situation is, your case with her is done, and you've got this shoplifting charge that you need to resolve. Ms. Wood will take care of the paperwork for today, and then Judge Ellerby, that's the other judge who will be getting your case, she'll set this down for whatever's next. All right?
Thank you, Judge.
You bet.
Can we do Mr. Rigby really quickly?
Sure, what are we doing with Mr.? Okay. Yep.
Rigby, y'all are Rigby. Hey, Mr. Rigby. Yeah.
Mr. Rigby, good morning.
How you doing, man?
I'm all right. I'm Judge McBurney, and your case has been assigned to my division. Ms. Wood is going to be representing you. She is waiving arraignment on your behalf, meaning entering a plea of not guilty at this time. That triggers the state's obligation to get to her and ultimately to you all the discovery in the case. That would be if there's a statement from the alleged victim or police reports or crime lab reports, all that'll start flowing to Ms. Wood. She's going to look at it, talk with you about it, and figure out the best way to move forward with your case. Even though we're meeting today, this will probably be the last time we meet because my criminal cases are being reassigned to another judge. Same lawyer, you're going to keep Ms. Wood. That's the good news. The neutral news is it's just going to be a different judge who will be overseeing your case. So when you come back to court next time, you actually be 2 doors down with Judge Ellerby. Ms. Wood, on behalf of you, and then an attorney named Ms. Williams, probably, although the DAs, they may be reassigned, will be handling it for the state. Okay? Any questions about that? Okay. Ms. Wood will, or someone from her office will be out to see you soon once that discovery shows up. All right? You bet. Welcome back. We just arraigned a defendant of yours, Mr. Rigby. So, why don't we, do you have an update? Are we ready to go with Okoro or what's the latest?
I believe, Your Honor, that defense has an update. I could step out if you would like for Ms. Kim to provide you with that.
Yeah, why don't you bring her in and we'll talk about Ms. Dickens right now. So Mr. Wardlaw, if you and your client can come on up to the podium.
Yes, Your Honor, I was gonna see about this. I want to see the prosecutor briefly, because I'm with the case.
Sure. Okay, well, why don't you, before you guys come up, why don't you and Ms. Smith talk some about the case? Ms. Smith is right there. And she's actually available because I'm going to hear from Ms. Kim about the Okoro case. Good morning.
Morning, Judge.
So we are on for the 414 notice hearing. And I don't know if you were involved with the case back when it was filed, but Mr. King, well, the state obviously filed the notice, and we were going to proceed with a proffer. And this goes back several years. This is a case that has gotten too old, not your fault. But Mr. King exercised his client's right to say a proffer is not sufficient. I want the state to present the evidence that would allow the judge to determine if the state could prove by preponderance at trial that the other alleged acts of molestation had occurred. And based on current appellate case law, if the defense says proper is not enough, it's reversible error for me to say proper is enough. And given that, we tried to schedule it. I don't know if it was the alleged victims or their guardian or parent, but there was a health issue that prevented them from traveling initially. And so if they were going to testify a year ago, whenever it was going to have to be via Zoom. It wasn't safe for them to be here in court. And Mr. King, again, exercised his client's rights to say, nope, Sixth Amendment, they need to come testify in court so that my client can confront them, not physically, but I want them to be here in court. It took a while for things to be safe for people to travel. We may even had to reset it one more time after that, but this was the line in the sand. The state has taken a whole bunch of steps to secure the presence of the 2 victims, and I don't know their age, but this was long enough ago. They may have a parent with them. I don't know if that they require to have a parent.
Your Honor, so there are 2 victims and 1 corroborating witness. All 3 are adults and they are currently in the courthouse.
Okay, and they're all related in some way.
Yes.
Yes. Okay, so they're all here. And so this is the day to do it. As you could probably glean from the email traffic when there was a request for shifting things around and I said no. So your update is ready to proceed?
Verified that they had tuberculosis. We verified that? That's my understanding of why it's reset to begin with.
I mean, I wasn't gonna add,
It's just such a low.
So the last-
Rate of tuberculosis in this country that I was just curious, so.
So the last reset was for my family loss.
Not that.
Yeah, so previous to that, I know that my 3 witnesses who are here now, they were preparing to get on a plane and there was scheduling issues with attorneys. So that wasn't the reset prior to that.
right, we didn't do a reset, we just set things out very, very far because of the purported ailment. I wasn't gonna air it out here, but it is what it is, and you're welcome to ask them about it, but they're clear to travel now and they're here. But that was why it was going, if it was gonna happen back at the time, once Mr. King asserted the right to confrontation, it was gonna have to be by Zoom. And Mr. King said, Zoom's not okay by me. And there wasn't a way to have an in-court appearance back then, based on what was represented to me. I didn't ask for medical information. If Mr. Okoro had been in custody, I'm sure we would have pressed this more to say, hey, it's not enough to say it, you got to show it. But Mr. Okoro has enjoyed liberty since these charges were brought here. And so Mr. King simply relayed, when it's safe for them to travel, we'll set this down. And then for the reasons Ms. Williams has described, we had a couple resets. But the stars have aligned and we've got everyone here.
Judge, we wanted to see if we could go ahead and set this for a non-negotiated plea. My colleague is, I'm just gonna let you know, he is in Barbados or going to Barbados. It's his wife's 50th birthday. It is a huge event for their family. So I think this has been planned for a while, but I wanted to see if we would need family members here as well for our client. Some witnesses on his behalf that this one.
So what I'd be willing to do, and you can talk about this with Mr. Okoro, is to take the plea half of things so that he has pled because the people have traveled all the way here. And then we'll defer sentencing so that you can get your witnesses here and Mr. King can be here. But I'd have to get that far to say we won't do the 414, given the steps that the state's taken to get the people here and the commitment they've made to be here from far away. It would need to be, we'll do the plea part and then full stop, and I'll handle the sentencing. I know my docket is going elsewhere, but I'd hold on to that. So why don't you talk with Ms. Williams to see if the state is amenable to that? But you know, we're past final plea, so that will have locked in the plea. I don't need to worry about that. And then we would just do the non-negotiated plea at a date and time that works for both the state and the defense.
Does we have a right to withdraw the guilty plea if the number goes up?
I'll have to look to see if we've done if we've already passed the final plea date. We may not have because we weren't able to do the 414. But initial reaction, Ms. Williams?
Your Honor, the state has a couple of issues. First of all, regarding a plea hearing, the 3 witnesses who are here today are also family members of the victim, and the state would also present them as child hearsay witnesses at trial. The incident victim confided in these 3 witnesses.
Mm-hmm.
The incident victim is in the military, and so it would take a lot of doing, giving everything that the military is involved in right now to be able to even get her on Zoom and definitely get her stateside. So I would request that we be able to present testimony, thoughts, words from the 3 victims and witnesses who are here today as part of the state's presentation. Second of all, there was a final plea date. I don't know what was done with that date, but I did note that on the docket because Ms. Clark, the previous prosecutor, had provided an offer that expired at the final plea calendar. So that offer had expired. So I just want to make sure that the state's resources are being protected because of course we did fly these 3 witnesses here today.
Sure, and I'm mindful of that as well, which is why the bare minimum that we'd get through today would be the plea part, and then we would defer sentencing. I want to make sure I followed what you said. because you've got three witnesses here who are really part and parcel of your case in chief as well, independent of 414, because of the child hearsay component, your request would be that they give their equivalent of victim impact statement. And for two of them, they would in fact be victim impact statements. As part of what would be sentencing, and that'll be part of the record, but that way they don't need to be back here for the sentencing part, and they're able to give it face to face rather than, because they could always connect via Zoom when we get to the sentencing side of things. But because they're here, you are asking that that piece of sentencing happen today.
Yes, Your Honor, we are. And alternatively, the state is fine with anybody who can appear via Zoom today. We're willing to wait today for any family members of Mr. Okoro who would be able to appear via Zoom to provide a statement. We're here all day.
Hold on one second. I think the missing piece though would be the victim in the case in chief, because it sounds like you would not be able to get her on Zoom today.
No, we would not. We would waive her presence for sentencing purposes and have her close family members who she confided in and is close to.
So you would actually, I'm not saying we're going to do this, but you would be prepared to go all the way through plea and sentencing, even though the victim named in the indictment would not be heard directly. It would be through family members.
Yes.
You wouldn't want to, oh, wait, we got to hear from her in 2 weeks or something. Okay, all right. It sounds like that's not something you are able to do, or you want Mr. King in the mix.
He's lead counsel in this case.
Okay.
Counseling, but he's lead counsel.
Okay, and so your request would be to defer the sentencing component until a mutually agreeable date. And to be clear, I'll keep the case. I know other things are sliding across, but my role is going to end with a ruling on 414, but my role will end with sentencing if we do the plea half of things today. And it sounds like you don't object to that, but you are saying we could, from the state's perspective, actually get all the way through sentencing.
Oh, the state is fine with you remaining on the case, Your Honor. There's no objection to that.
Okay, that wasn't what I would appreciate. I feel loved, but I wanted to make sure you were not objecting to, we take the plea, we lock in the, I find you guilty, but then we don't get to, and the consequences of a guilty plea is sentence X. We would do that much of it, and we would hear from the three people who have traveled from distant corners.
So the state is fine with that if we get clarification about whether or not Mr. Okoro will be able to withdraw his plea.
Right, because otherwise we should do the 414. Okay, let me look into that, and we're going to handle Ms. Dickens's ankle monitor situation. Okay, good. All right.
Judge, I'm done. I got another announcement about their case.
Oh, yes.
Corey Gross.
Okay, Corey Gross, what's that announcement? Is Mr. Gross in custody?
He's online.
Hey, tell that dude to come on, they own.
Is he the one in state custody?
He's not, Judge, but I'm gonna go.
Okay. Oh, there it is, Corey Gross. All right, so he's on. What's the announcement?
Just need a walk-in today, and we're not gonna be able to come to any kind of agreement, so if we could get a setting so that we could get noticed and have it here.
Okay, and this was for a revocation, so he's got a warrant? So this was a walk-in who didn't walk in, who's got a warrant. Were you expecting him to be here, Ms. Kim? Hopeful that he'd be
I was
here?
hoping to resolve it today favorably, so we can just appear via Zoom.
Judge, this revocation meeting.
There's Mr. Gross. Can you go to the podium, Ms. Kim?
His office has some issues.
Okay. Hey, Mr. Gross, can you hear me?
Oh, yes, I can hear you.
Great. This is Judge McBurney. Any reason you didn't come to court today?
That was my fault, Judge.
Oh,
Has nothing to do with, yeah.
okay. The reason would be Ms. Kim, who's standing right there. We're not able to resolve your case today. You will need to come to court for the date that is set for your revocation. And you should know there is an active warrant for you. So if you run a stop sign and get pulled over, you're not getting a ticket, you're getting handcuffs, and you'll be in custody until we can have the hearing. It's a little awkward that you're not here today because there's this warrant out there, and I'm not in a position to set it aside because the state and the Department of Community Supervision are going to be advocating for something different from what Ms. Kim is advocating for. So you need to be very careful between now and your court date, okay?
Okay.
I don't know that I can get you a court date because it won't be with me. But what we can do is, well, why don't we do this since we have Mr. Gross on? Ms. Nelson, have you, in working with Judge Ellerby's staff, been able to set dates, or how would we do this? Because it would, oh, hold on, I just got a little notice.
Judge, I can put it on another probation revocation calendar for Judge Ellerby.
Okay, you're able to set a date?
Yeah.
Okay. If you could let us know that date so we can tell Mr. Gross, that would be great.
Let me grab my phone. Just okay, I'll pull her calendar up just a moment.
Thank you. Ms. Nix, do you know the case number?
Yes, sir. I believe it is 24 SC 00071.
Thank you, Ms. Nelson. Oh, it's sealed. Is it a first offender? Okay. I was just going to try to check his address. Mr. Gross, did you get any? Well, you wouldn't have received anything in the mail. I'm telling you now, and I hope we have a good address for you in the system, but your records are sealed. You need to come to court on July 21 at 1 p.m. July 21 at 1 p.m. and it's courtroom 8B as in Bravo or Braves.
Okay.
Okay, what time and where?
July 21st, at 1 p.m. And it's, courtroom, you said Bravo?
8, the number 8 followed by the letter B.
8B. Okay.
Yeah, 8B. Ms. Kim will be there. Yes, Ms. Kim?
Yes, Judge.
Okay, and the prosecutor will be there and they'll work through the situation then, okay?
Okay.
All right, see ya.
That's
All right,
Judge
thank you.
Ellerby.
There is Judge Ellerby.
Okay. And then I'm just gonna pop in the back, speak to Thomas Smith, and then we should be ready to go on the plea on that one.
Okay.
Is there any plea paper we've done? Like I thought you said.
I think we signed the.
I don't remember.
drug court stuff.
Okay. We did on the drug court.
Yeah, but there's just everything else.
Yeah, everything else will be verbally. And Mr. Okoro has already had his final plea and didn't resolve the case then. So he is welcome to enter a plea today. He will not be able to withdraw that plea if he doesn't get the sentence that you and Mr. King advocate for.
Would it be possible, since Mr. King is lead on this one, he's aware of all the issues on the motion, that we could reset it for him to be here?
The 414?
Yes, Judge.
No.
Okay.
But it's not a motion. It's the notice from the state, and the state would be establishing, if it can, by a preponderance of the evidence, that Mr. Okoro molested 2 other, are they nieces? Cousins. It's laid out in the notice, one in a fair amount of detail and one in a very limited way. I assume that was one of the reasons why Mr. King asked for the hearing rather than the proffer. So there's not a lot of prep he could do beyond reading the notice,
right,
unless he reached out to those people. I'm guessing they wouldn't have talked with him, but so we'll go forward with the 414 and I'll learn more about that situation today, or we'll do the plea part of a plea, which Mr. Okoro is not free to withdraw if, when we get to sentencing, which will not be today, he'll leave with you today, if he's dissatisfied with the sentence. So you can chat with him about his choices, and we're going to pivot to a few other things.
Okay, so I'm gonna go talk to Thomas Smith first and then.
Whatever order you want to do it. You have a busy morning.
Thank you, Judge.
Okay. Ms. Dickens and Mr. Wardlaw, if you'll come on up to the podium, please. Oh, and give me 1 second. I gotta put in the breakout room. Let's do this. Are you Mr. Greer? Great. If they could unmute you there, Mr. Greer, I'm going to put you in a breakout room with Ms. Wood, your lawyer, so the two of you can speak privately, okay? But for that to work well, you're going to need to unmute. Don't go too far. Excellent. I think you're unmuted. Can you hear me, Mr. Greer?
Yes, sir.
Good, I can hear you. All right, I'm going to click a button in just a second, and you're going to go into a breakout room with Ms. Wood.
Yes, sir.
And we'll see you in a little bit. There you go. They're in. Okay. Good morning.
Good morning.
Good morning, Your Honor.
Mr. Wardlaw, I don't think we've met before. Welcome to Ms. Dickens's case. Did you have a chance to speak with Ms. Smith about it?
Yes, Your Honor.
Okay. We are here to talk about the curfew. Ms. Dickens has not gotten a good grade from the ankle monitoring company. The trip to Florida, I authorized. They got worried about that, but I'll explain to them why that was not a violation. But Ms. Dickens, according to her or some family member, it's because of DoorDash or the nature of her work. But the curfew is the curfew. It wasn't an optional thing or a try it when you like it kind of thing. Ms. Dickens has connections to faraway places, and the whole point of getting her a bond with those restrictions was to ensure that we knew where she was when she was supposed to be in certain places. And since then, you have a very communicative client who emails me directly. You may want her to not do that. She's offered up a new place to live, as well as reasons why her curfew should be changed. So I'm going to hear from you. If you think it's important that I hear from Ms. Dickens, I'll also hear from her. And then I'll hear from Ms. Smith, and we'll figure out whether bond is just not working at all, or if there are things we need to modify to make sure that Ms. Dickens is having less trouble complying with the curfew.
Yes, Your Honor.
Okay, I'll let you start.
Yes, Your Honor. I do think it's important for you to hear from Ms. Dickens today, and she's prepared to address the court directly. We would ask the court not to revoke Ms. Dickens' bond, and we ask the court to treat the previous curfew violations as resolved and to modify the bond as necessary rather than revoke it. Ms. Dickens was removed from the residence. I don't know if you received the police report.
Removed from
the housing. It's a housing issue where she was staying at. The police responded, and she had to, now she is staying with Miss Nia Johnson. And I filed the most, Nia Jones. And her information is filed with the court, and she was supposed to be present today, and that was one of the reasons why I wasn't trying to rush this hearing.
Okay, well, maybe she'll still make it, or she can get online.
And I just texted her about the Zoom option. I don't think she knew there was a Zoom option.
Okay.
Your Honor, the facts show instability in housing, not instability in compliance. The fact that she went to Florida and returned here today shows that she's not trying to not appear in court for her trial, and she remains available for court. So we asked today that the bond be modified, not revoked.
Okay.
Ms. Dickens would like to address the court herself as far as some of the things that I wasn't here for, because another problem was she had previous counsel who withdrew, and then she was representing herself, and then I was retained.
And she still represents herself. And I don't know if it's mom or someone else, but she's got a whole fan base that likes to file things and send things. So if I were to go to 684 Holderness Street, you don't live there anymore?
No, sir.
Who used to live there with you? Or, I mean, was that just your place or were you staying with someone?
I was staying with someone that allowed me to stay there with the conditions of the bond, using the address. Before,
And you got kicked out?
no, I removed myself because the party that allowed me to stay there seemed to be sketchy, and
Who is this person?
it was a guy. Okay, well, it was a guy friend, and after I wouldn't agree to sexual actions, I was asked to leave.
Okay, and you should, I'm glad. So you're in a safer place. Okay, but you're not at 684 Holderness.
No, sir.
Are you staying with a different guy friend or is it a,
No, this is my friend. This is my high school.
oh, the
friend.
Nia Jones person?
Yes.
Okay, and that is proving to be safer?
Yes, a lot safer.
What is that address?
That is, sorry, I don't know it off the head. It's at 7170 Cavender, is it Road? Right there. Yes, 7170 Cavender Drive, Southwest Atlanta, Georgia.
Cavender Drive.
Cavender like lavender, but with a C.
Yeah, okay, and that's with Nia. How do you spell her first name?
Naya
Jones?
Jones, Jones.
Yeah, okay. And who else lives there?
Her dad.
Her dad.
Your Honor, we have a phone number as well.
I'm not gonna be calling. It's okay. Does Miss Jones work?
Yes,
What does she do?
she does carrier work as well as I do.
Carrier, is it mean that's like DoorDash and Uber Eats?
So that's part of the carrier work, but I do mail delivery, packaging, taking it to homes. I
Okay.
get about anywhere from 50 to 70 packages I have to deliver. And some of the violations were due to me not finishing the route or having to do an emergency return back to the warehouse.
Okay, but that's what you mean by carrier work?
Yes,
Okay, and Ms. Jones does the same thing?
yes,
Does her dad work?
yes. I don't know where he works. I think
Okay.
he does security.
Okay. So it's just the three of you at that address?
Correct.
And has Ms. Jones said you can stay there for the foreseeable future, or did she give you 2 weeks?
No, foreseeable future.
Okay, are you paying rent?
No.
What are you doing to carry your weight there?
I help with the utilities, the light bill,
Okay. All right, and how long have you known Ms. Jones?
since high school.
Did you go to high school here?
Yes,
Where?
North Atlanta.
Okay. So you're working, but this carrier work makes the curfew complicated.
Exactly.
What curfew would work? Because you can't have a job where I could be driving at any time of night, because then there's really not a curfew.
Well, that is one of the modifications I would consider. I don't mind any other stipulations, but the curfew does make it hard because outside of that, I also do content creation and event videography, which the hours vary, so it's all over the place. And the curfew does intervene.
Right, but part of the point of the curfew is so you're not all over the place until you resolve these charges. It's being all over the place that raises the concern until you sort the case out. What curfew would work better besides no curfew?
Is 1 a.m. possible? 1 or 12 a.m.?
And when would it end? So when would you, if you had to be back, let's just pretend, that's probably a little later than it would be, but let's say it was, you need to be at 7170 Cavender Drive by midnight. Then when would you need to next leave Cavender Drive?
The earliest I can get a route is 8 a.m.
Okay. If your curfew was midnight until 8 and you got a route that was at 8, would you just say, I can't do that route, or what would happen?
I would have to do a route that allows travel time from the start time.
Okay. So you might have to say no to a few routes, but there'd be other routes you could get.
Correct.
Okay. And the content creation and other things that you do, those are the things that would cause you to be out later?
Correct. Nightlife, as far as some of my clients are rappers, that want footage recorded, things of that nature. So
Okay.
I have to be there behind the camera to shoot, to be able to edit, to produce the product.
Right. And they're not doing their thing at 3 p.m.
Unfortunately, no.
And Your Honor, I would like to point out that Ms. Dickens is not even accused of being a threat to the society at large. This was a domestic incident. I mean, against, it was a domestic where, well, our defense is that it was self-defense, where, a TPO was already filed and granted in Fulton County. So it's not a situation where the defendant is accused of, endangering the public.
Right. Shooting up a nightclub.
Yes, Your Honor.
Okay, I understand that. There's just the location concern stems from the fact that Ms. Dickens ended up in Florida and it was complicated getting her from Florida to here. So I'm not.
Yes, Your Honor. Her minor, I think one of the things is Ms. Dickens has her minor child in Florida.
I've heard a lot about that in some of the emails I get too.
Yeah.
Okay. All
Yeah,
right.
so since the case originally came about, I allowed him to go down just because of the conditions, with not knowing what's gonna happen, in regards to it. I have him down there with my grandmother. When I was caught, I was at the port taking him on his Disney cruise for his 7th birthday.
I heard that's got to be a little traumatic to be
It is, he's in counseling.
taken away from your kid while boarding the magic ship.
And to be in their Mother's Day and actually get transported on Mother's Day for 24 hours.
Yeah. Ms. Smith, have you had a chance to think about this case and I'm assuming it's not something that can be resolved today?
Correct.
Okay,
Regarding the modification or the reason that we're here today, the state is not going to be asking for the bond to be revoked. However, to respond to first the curfew, I believe that the original curfew was 8 a.m. to 8 p.m.
other way around, but yes.
In this case, the state would agree to a 10 p.m. curfew, but staying out until 1 a.m. is not something the state will consent to.
You sound like a parent.
We do believe that since the defendant's job allows her to kind of be flexible with the routes she takes, or if she's able to pick up a shift, we think that if the curfew was 8 p.m. or 10 p.m., she will have the knowledge to know she's not to pick up another shift when it's so close to curfew. The charges we have in this case, they are pretty serious, so we do want to at least see that the defendant is being serious by abiding by those bond conditions. So regarding the curfew, the state would agree to at least another 2 hours, which is 10 p.m., but not as far as 1 a.m. Also regarding the address, if there's a new address that the defendant is staying at, the state does not have a problem with that new address. We would just like to confirm in some type of way that the defendant would be there rather than speaking with the person who she will be living with. But other than that, we don't have anything other to add. We would just like to say if there's another, violation of this curfew, or there's another address that's not updated and she no longer lives at the one she's provided us with, the state will be asking for the bond to be revoked in that case. But for now, we're asking for the bond not to be revoked, just with those modifications that I mentioned.
Okay, that's very reasonable. Mr. Wardlaw, anything you want to add?
Not that, only that it would be confirmed that where she is via the ankle monitor that she has. So that would, like, when she's at that place, the court would know.
Right.
Whether or not she's there or not.
Right. Okay. So Nikhil Harvey, is that a male or a female?
A male.
A male, okay. And he doesn't live anywhere near Cavender Drive?
Not that I'm aware of. We have no contact.
Good, okay. So wherever he is, you're not sure, but you don't have reason to believe he's near Cavender Drive?
Correct.
Okay. How did testimony go?
Not guilty.
Really? That was quick.
100%. Because the sworn statement I provided was a year before discovery, and it all aligned. It was the truth.
Okay. So Ms. Dickens, I will modify your bond. I will have the curfew run from midnight to 8 a.m. and I will change the residence from the Holderness address to this Cavender Drive. But we've hit the zero tolerance phase. If there's another alert from Second Chance, then you should just come on in. So be real thoughtful about what routes you take. Let potential clients know, hey, I can be at your event, but I turn into a pumpkin, or my carriage does at midnight. So I got to leave before then because I need to be home. You've used up your, but what about this? What about that? You and Mr. Wardlaw should work with Ms. Smith about, is it going to be your case or is it a Ms. Willingham case?
Well, one second.
I don't think the way it's charged, it would be with Ms. Willingham.
It's my case.
Okay. But Mr. Wardlaw and Ms. Smith can start working on seeing if there's a resolution to the case. If something changes in your life such that you need to seek another modification, seek the modification before you start modifying it yourself by doing different things. Does that make sense?
I understand. You got it.
Good. I heard you say that. So that means you do understand, and I shouldn't have to get any more emails from Second Chance or the people who support you. They should send emails to Mr. Wardlaw. Okay. All right. Mr. Wardlaw, anything else?
No, Your Honor, that concludes our case for today. May me and Ms. Dickens be excused?
Sure. Ms. Smith, anything else from the state?
Nothing further, thank you.
All right.
Man. So how do you, I won't be here about it. You will be.
Ms. Wood, did you get a chance to speak with Mr. Greer?
I did, Judge. We're ready to proceed when the court's ready.
Is it a plea?
It is.
Okay.
Negotiated.
Why don't we do that since they're on, I think he's still stuck in the breakout room, so I will pry him out. Mr. Greer, can you hear me?
Yes, sir.
Great. Ms. Wood tells me that you're prepared to go forward with a plea. Is that correct?
Yes, sir.
All right. Ms. Watson, we're going to get on the record. I need, nope, I bet I don't need, hold on. Let's look here. Okay. Ms. Watson, are you ready?
Yes, I'm ready.
Great. This is case 26 SC 000811. It is State versus Greer. Mr. Greer is joining us from the Department of Corrections. He is represented by Ms. Wood, who I will get on the screen right there. And the state is represented by Ms. Smith. Mr. Greer, normally when we're doing something like a guilty plea, the defendant is here in court, a public space. You are appearing from Dooley State Prison. Do you waive your right to be here in court, and do you agree to proceed virtually?
Yes, sir.
You also have the right to have Ms. Wood right by your side so that if you need to talk to her, you can just lean over and say something to her. But as you know, she's here and not at Dooley State. Do you waive your right to have Ms. Wood by your side?
Yes, sir.
If you need to speak with her, let me know. We can get you guys back into a breakout room. I don't think anything will come up, but that's your call, not mine. So let me know if you need to chat with her, okay? Mr. Greer?
Yes, sir.
Okay. Let me know if at any point you cannot hear us here in Atlanta, or if you've got a question about anything that's going on. Will you do that?
Yes, sir.
All right, Ms. Smith.
Thank you, Judge. Mr. Greer, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
DeMarcus Greer.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charge in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waived.
Mr. Greer, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
Yes, ma'am. No.
So the question was, are you aware of any other warrants, or have you already been arrested on the case? Any other warrants you think are out there?
No, I only got no warrants. No, ma'am. No,
Good.
Mr. Greer, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 1 with the balance probated?
Mr. Greer, do you understand that's the state's recommendation? Did he freeze up? Oh, he did. Darn. Well. Moved there. Mr. Greer, can you hear us?
Yes, yes, sir.
Okay, it froze up. I don't know. I'm going to have Ms. Smith repeat her last question, which was about what the state's recommendation is, and we'll go from there, okay?
Yes, sir.
Mr. Greer, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 1 with the balance probated?
Mr. Greer, did you hear that?
Yes, I said yes, yes, I heard.
Okay, we didn't hear your yes part. I think we've got a little bit of a sketchy connection with Dooley, but we'll keep going, okay?
Yes, sir.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on this charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you also understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
I think we just wait. Once he starts moving, he's probably already answered, but. They usually have pretty good connections. Mr. Greer, it froze up again. I know that's not your fault. We're going to try one more time to get through this, but if it keeps freezing, we're going to have to see if they can get you a better connection down there, okay?
Yes, sir.
Okay. So what Ms. Smith had just asked is this, whether you understood that while the state is recommending 5 to serve 1, you understand that I'm not bound by that, and I could sentence you to any legal sentence to include all the way up to the maximum, which in your case would be 20 years to serve. Do you understand that?
Yes, sir.
Mr. Greer, are you a United States citizen?
Yes, sir. Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you
Yes,
did,
ma'am.
you'd be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights they'll be waiving by entering this guilty plea?
I am.
Mr. Greer, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 26 SC 000811, how do you plead to count 1, burglary in the first degree?
Plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Greer. Your Honor, if this case were to proceed to trial, the facts would show that on August 3rd, 2025, officers were dispatched to 1059 Coleman Street, that's in Atlanta, Georgia, and also in Fulton County. This was a residential home. When the officers got there, they spoke with the victim, Tobias Greer, first name is spelled Tobias, who informed the officers that his cousin, the defendant in this case, had burglarized his home. Mr. Greer, Tobias Greer, the victim in this case, told the officers that he was at a event with his cousin previously that night. So he left his home, and when he left, he had it was like some type of social event that he went to, and his cousin was there amongst other people. But distinctively, he remembered what his cousin had on, the defendant in this case, my apologies. And when he got back home, he realized that his house had been burglarized. So while at this social event, he stated that Mr. Greer, the defendant in this case, left before him. So when he got back home, he saw that his front door had been forced open. He has cameras around his home, and when he went to watch it, he saw that the defendant in this case was attempting to gain entry to through the back door, but it was locked. He wasn't able to get in. And then you could see the defendant going around to the front. He doesn't have cameras, so he wasn't in the front. So he wasn't able to see him entering the door through the front, but because he was trying to enter through the back and the front was open, that was the logical conclusion here. The officers were able to review that camera footage. He did tell the officers that the victim was unable to provide a list of things that may have been stolen from the home. So the defendant is not charged with theft by taking or theft by receiving or anything like that. However, with the video footage and the evidence of the defendant in this case breaking into his cousin's home, he was charged with burglary in the first degree. The state in this case attempted to contact the victim and his when we tried to contact the victim, we were notified that he was deceased back in March of this year. However, we did run a check on the victim and we got a number for him, and we called that number and the person answered and said, "Hey, I told you why I don't want to talk to you anymore." So it's kind of unclear on if the victim is alive or not, which is why the state is unclear on if we should ask for no contact with the victim or no violent contact, because we're not too sure about the status of the victim. However, regarding the negotiated plea between the state and the defense, we've agreed to a sentence of 5 years to serve 1 with the balance probated, and that's for the year to run concurrent with the current sentence that he's serving. Regarding the special conditions of probation, the state is asking for an anti-theft force for the defendant to stay away from the incident location, and also for the defendant to complete a drug and alcohol evaluation with treatment if necessary. And again, I wasn't too sure on what to add regarding the victim because of the circumstances, but that is all from me, State.
All right, thank you. Good morning, Ms. Smith-Mann.
Good morning, Your Honor. I'm sorry, was having problems getting on.
Well, it's great to hear your voice. Do you have any criminal history information on Mr. Greer?
Your Honor, I have 7 cycles, not including the one that is before you today. There are 3 felony charges from April 05, 9/2018, 12/2018, a 2/26 probation violation and revocation on 3/26. Nothing further, Your Honor.
All right, thank you. Ms. Simpson, is Mr. Greer on probation now? He was revoked, but there's time remaining on that case. And was this arrest the basis for the revocation? Okay. How long did he get revoked for?
11 months.
Okay. Ms. Wood.
Thank you, Judge. Mr. Greer is 39 years old. He is from Atlanta. He does have family here. Judge, he has a 6th grade education. He was unfortunately unemployed at the time of this incident. I'm hopeful that he's going to be able to get some programming while he is with the Department of Corrections. He has been in custody there since April of this year, and so we would just ask that you accept the state's recommendation for this case.
Okay. Hey, Mr. Greer, you still with us?
Yes, sir.
Great. I got a couple questions for you, and then if you have any questions, it'll be your turn. So Tobias Greer, that's your cousin?
Yes, sir.
Okay. As best you know, is he still alive?
No, he's not. No, he's passed. He passed.
I'm sorry to hear that. Okay. The house where he lived that you are pleading guilty to entering, are there other family members who stay there? He froze up. Almost done.
So close.
I know. I shouldn't have asked any questions. But I wanted to clear up the whole Tobias Greer thing.
Okay.
All right, I'm gonna leave him up on the little screen. Maybe that'll help. Hey, Mr. Greer, My question was, and you may have answered it, but we couldn't hear you because it froze up, was whether other family members of yours still live at Tobias's house.
I really don't know. I don't know. I really don't know.
Okay, well, I'm gonna have you stay away from that address just in case, but I am sorry for your family's loss. Do you have anything you want to add or any questions about anything we discussed?
No, sir. I was just hoping that I could be recommended to a TC or something that could help me. You know what I'm saying? Better myself when I do get out. You know what I'm saying? Like, because I'm homeless. You know what I'm saying? So I can be able to go to a TC to be able to, to stay with myself before I get out.
Tell me what you mean by a TC.
A TC like it's like a work release. It's a work release.
Got it. Okay, I will certainly recommend that. I don't get to tell the Department of Corrections what to do, but it sounds like that would be a great opportunity for you, and so I will recommend that. Mr. Greer, I find there's a factual basis for your plea. Sounds like you were working through some tough times. I also find that your plea was knowing, meaning you've understood what we talked about, and voluntary, meaning no one forced you to enter the plea. Do you agree with that?
Yes, sir.
Okay, I'll accept your plea. Ms. Wood, do you authorize someone in my office to sign the indictment on your behalf and Mr. Greer's behalf?
Yes.
And Ms. Smith?
Yes, Judge.
Great, we'll do that. Mr. Greer, I'm going to follow the negotiated resolution and sentence you to 5 years to serve 1 year with the balance probated. You'll get credit for the time you've been in, and this sentence will run concurrently, meaning at the same time with your revocation. Special condition of probation number 1 is that you stay away from 1059 Coleman Street. That was Tobias's place. Special condition number 2 is that when you get out, probation will help you do this, but you're going to have a drug and alcohol abuse evaluation. And if any treatment is recommended, that treatment will be part of your probation. The last thing I'll do, Mr. Greer, in your sentence sheet that I fill out is that I will recommend to the Department of Corrections that they consider you for transitional programming, whether it's a halfway house, a training program, the reentry program at their facility over in DeKalb, but there are a number of options that might help you out. It sounds like you are ready and willing to get some education, some training, something that'll help you so that when you get out, you don't find yourself in the same difficult situation you were in before all this happened. Ms. Wood, anything else on behalf of Mr. Greer?
No, thank you.
Ms. Smith, anything else?
Nothing further, thank you.
Ms. Simpson, he just needs to report within 48 hours of his release? Okay. Mr. Greer, when you are released, make sure you report to probation within 48 hours of your release, okay?
Yes, sir.
All right. Thank you, Dooley State, for connecting us.
That's good. Okay.
Hey, Mr. Jordan. How are you?
Yeah.
Okay, there we go. All right, Ms. Watson, we are going to get back on the record. And I just need to get my hands on the calendar. Mr. Jordan's not on the calendar. This is another one of the
Yes.
Ms. Wood's request. Oh, this was a carryover from last week.
Yes.
One of your clients had 3 cases. Is that this client?
Yes.
Okay. I don't have Thursday's calendar. So if you could get me those 3 indictment numbers, please.
So the oldest one is gonna be 21 SC 178640. And then there's a 26 SC 000824. And then finally the 26 SC 000825.
All right. Now we can get on the record. Mr. Jordan, good morning.
Morning, how you doing, sir?
I'm all right. Ms. Wood tells me you actually were probably ready last week, but you are definitely ready now to enter a plea in the 3 cases. Is that correct?
Yes, sir.
Okay. Ms. Smith, the prosecutor on your 3 cases, is going to swear you in just a moment. Once you're under oath, make sure you answer all her questions and mine truthfully and completely. Will you do that?
Yes, sir.
It's also important that you let Ms. Wood or me know if you've got any questions of your own. Will you do that?
Yes, sir.
Okay. Then we are on the record with those 3 indictment numbers. And Ms. Smith, when you're ready.
Thank you, Judge. Mr. Jordan, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your true, correct, and legal name for the court.
Calvin Dwayne Jordan.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
No, no.
How old are you and how far have you gone to school?
50 years old.
You said 50?
Yes, sir.
And how far did you go in school?
I went to 9th grade, but I ended up getting my GED.
You did get your GED. Great.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in these 3 indictments?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
Okay. And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waived.
Mr. Jordan, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
We are not.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve 1 with the balance probated?
Yes, ma'am.
Do you understand that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you also understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to this felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you also understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights they'll be waiving by entering this guilty plea?
I am.
Mr. Jordan, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 21 SC 178640, how do you plead to count 1, possession of a Schedule II controlled substance, count 2, driving while license suspended or revoked, and count 3?
Oh, please, just.
Hold on, let her finish and then you can ask me your question. Sorry, go
You
ahead.
good? Okay. How do you plead to count 1, possession of Schedule II controlled substance, count 2, driving while license suspended or revoked, and count 3, failure to obey traffic control device?
She's going through each indictment and asking how you pleading to the
I
indictment.
thought, don't charge that, I thought I was pleading not to flee into the moon.
No, it's all 3 cases that we talked about with the jail for the 10 circle and club resolution.
Yeah, I plead this.
So here's where we are, Mr. Jordan. You don't have to plead guilty to anything if you don't want to, and you can have a trial, and the state has to bring in evidence to prove it up. You've got 3 cases from what I can see. One is real old. It goes back to February.
I thought the statute of limitation ran out on this.
Well, COVID is why it didn't run out. The state put the magic language in that indictment that the Supreme Court of our state paused the statute of limitations during COVID. And so it actually is a timely indictment. You were indicted in 2021 for something that happened in 2019. And that's within the range, and the clock was stopped in part by COVID. So in one case, you're charged with, I'm assuming it was a red light, running a red light, didn't have a good license, had a little bit of cocaine on you. That's the real old one. The newer ones, we got February of this year and July of last year.
Yes, sir.
We hadn't really gotten to those facts yet, but again, there were some driving issues. But today is the day to say, yep, I'm admitting my guilt, or at least I want to go forward. And we do what we call an Alford plea, where you say, it didn't really happen that way, but I still want to work the case out. Or you say, hey, bring it on, but prove it up. Bring in the officer who pulled me over. Bring in the officer who found the cocaine. Bring in the officer who chased me down when I was doing whatever you were doing in East Point back in July last year. The state has that burden, you don't. But if you want to work things out today with this offer of 10 serve 1, then your answer needs to be either I am pleading guilty or it's in my best interest to resolve the case. But if you want it to be a trial, just tell me not guilty and we're done.
No, I ain't trying to do that. I got a question like, I'm trying to handle everything today.
Okay.
I was just trying to see, can I get like, instead of like a 10 to 1 year, can I get like 10 to 12 months?
So Ms. Wood can argue for things like that for you. I don't know legally that's an option, because I think one of your convictions for fleeing and attempting to elude is a mandatory, it's a felony. And so felonies are years, not months. I know what your angle is, because hey, you're a smart guy. But I don't think with fleeing and attempting to elude, I could legally sentence you that way. But let's get through the part where if you're admitting to it, let's do that. And then we can get to what does the sentence look like, okay? So the question on the table was, how are you pleading to? Okay.
As to indictment number 26 SC 000824, how do you plead to count 1, fleeing or attempting to elude a police officer during the commission of certain crimes? Count 2, reckless driving. Count 3, willful obstruction of law enforcement officers. Count 4, failure to maintain lane or improper lane change. And count 5, failure to obey traffic signs.
Plead guilty.
As to indictment 26 SC 0000825, how do you plead to count 1, theft by receiving stolen property, count 2, identity theft fraud when using/possession identifying info, count 3, driving without a valid license, and count 4, attempting to misrepresent a tag?
Plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction?
Yes, ma'am.
But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Yes, okay. Do you understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Jordan. Your Honor, if this case were to proceed to trial, starting with the indictment ending in 8640, the facts would show that on February 1st, 2019, officers conducted a traffic stop on a red in color Chevrolet Spark for running a red light. When the officers got to the car, they introduced themselves and gave Mr. Jordan the reasoning for the stop and asked for his driver's license. At that time, the driver, who was identified as the defendant, told the officers that he did not have a license, and gave them the name of Calvin Jordan. When the officers ran that name through GCIC, they saw that his license was suspended and that he also had a warrant for a probation violation out of Fulton County. At that time, the defendant was placed under arrest. The officers then checked his person, where they found a substance that was later tested and tested positive for cocaine. And he was taken into custody and arrested for the charges we have before us. For the indictment ending in 0824, if this case were to proceed to trial, the facts would show that on July 16th, 2025, officers of the East Point Police Department responded to a stolen car hit at 2838 Gus Thornhill Drive. That's in East Point, also in Fulton County. The officers saw that the car they were looking for was the red Chevrolet Spark, the same car from the last indictment. The officers then got behind that car to initiate a traffic stop. The driver was identified as Mr. Calvin Jordan in this case. Instead of stopping for the officers, he fled the area, running through multiple red lights in a reckless manner with blatant disrespect for or disregard for public safety. He also made an illegal right turn, causing him to start driving down a one-way street the wrong way. The officers were eventually able to stop the car, learned that the person that was driving was Mr. Jordan, and he was arrested for the charges we have in front of us for this indictment. And lastly, for the indictment ending in 0825, if this case were to proceed to trial, the facts would show that on February 4th, 2026, officers of the East Point Police Department was patrolling around Calhoun Avenue and Bell Avenue. Those two addresses or locations are in Fulton County when they saw the red Chevrolet Spark with a test drive tag. The officers in this case initiated a traffic stop and informed the driver, who was identified as Mr. Calvin Jordan, the defendant in this case, for the reason for the stop. When the officer asked for his license, he told the officer that he did not have it with him and wrote down the name of Ashley Lyons with the date of birth of March 21st, 1973. The information was incorrect and did not belong to the defendant. When the officer ran that information, the description of the person who came up for Ashley Lyons did not match the defendant. The officers in this case was able to identify the car as being registered to a Justina Jordan. The officers saw that the car came back as stolen and was reported stolen. So at that time, the officers did arrest the defendant for the charges we have in front of us for that indictment ending in 0825. In this case, Your Honor, the state did try to reach out to Miss Justinia Jordan, who is the registered owner of the car, or to see if there was like permission for him to get the car, since it was the same car in all three scenarios. We were unable to make contact with the victim in this case, or the person who owns that car. So we're not too clear on the availability of the defendant being able to get the car multiple times. However, those are the facts we have for those indictments regarding the recommendation between the state and defense. We've agreed to a sentence of 10 years to serve one for the defendant to complete an alcohol and drug evaluation, have gainful employment, and take an anti-theft course. And that is all from the state, Your Honor.
All right. Thank you. Ms. Smith-Mann, criminal history information on Mr. Jordan.
Your Honor, there are 40 prior cycles, not including the one that is before you today. There are 5 felony arrests, 8 misdemeanor arrests. There was a probation violation in 219. It does not tell me any additional information for that. And then there is a later probation violation, Your Honor, that does not give me a date. So hopefully probation will be able to help us with that. And that should be one past the 2019. Nothing further.
When you say 5 felony arrests, do you mean 5 felony convictions?
Yes, Your Honor, I am so sorry.
That's okay. So
That
out
is
of the
exactly.
40 cycles, there are 5 felony convictions and 8 misdemeanor convictions.
That is correct, Your Honor. I
Got it.
apologize for that.
That's okay. I just want to make
was
sure.
trying to do them as we were going because I didn't have this case, so I am so sorry.
Nope, you're all good. Thank you so much.
Okay.
Ms. Wood.
Thank you, Judge. Mr. Jordan is 50 years old. He's originally from Florida. He's lived here in the Atlanta area for the past 10 years. He does have family here, as you heard. He has 5 children. He does have a 9th grade education. I believe he has completed his GED. Your Honor, he struggles with cocaine usage. We actually referred him to drug court. He was eligible. However, there is a probation violation out of Clayton County and then a brand new case in Barnesville, Georgia, that
Involving the red Chevy Spark?
I'm not sure. But given those moving parts, and in speaking with drug court, and as you know, it's quite difficult to try to resolve other things to make it work, which is why we are hoping you will accept the state's recommendation in this case. One thing that I did forget to point out to Ms. Smith, so on the 2021 case, the one ending in 640, I don't know, it might make more sense. He did a significant amount of time. He actually got revoked, so he did about 26 months total since that arrest. And
He's been revoked on that for?
I don't know if it was the basis of other things, but he went to prison between 2019 and resolving this here.
Sure. What was the basis for you going to prison?
I was on probation here in Fulton County when I got pulled over for the cocaine and the marijuana. I was on probation here, and when I got pulled over, they violated it. They revoked the rest of my probation.
Got it. And that sent you down the road for a few years?
Yes, sir.
Okay. All right. Well, that'll probably resolve that one.
Yes,
Ms. Simpson, it sounds like there's an active probation warrant out of Clayton County. Is there any Fulton probation still lingering that we ought to address here? Okay, thank you. Mr. Jordan, do you have any questions?
No, sir.
Your kids, how young is your youngest kid?
19.
So they're all grown.
They're all grown. Yes, sir.
Okay. The red Chevy Spark that belongs to your cousin?
My mother.
Your mother. Your mother. Okay. Why was she reporting it stolen all the time? Would you take it from her?
Something like that. It's
Okay.
like,
All right. Is the Chevy Spark still out there?
mm-mm.
What happened to it?
I don't know what happened to her. I've been locked up.
Okay. All right. But that's your connection to it, is that it was your mom's car. And you might sometimes borrow it in a way that maybe she didn't
I use
appreciate.
the car all the time. She'll get mad with me and call the police on me if I don't come back.
It's a tough relationship.
Yeah.
Okay. All right. Well, Mr. Jordan, I find there is a factual basis in each of your 3 cases. Sounds like you've been wrestling with cocaine for a while.
Yes, sir.
It's too bad drug court won't work out right now. It doesn't mean that it could never happen. You've got to sort out Barnesville and Clayton. But if you get back here and are on probation and are testing positive, it may be that probation recommends that you go to drug court. That's not a sanction as in you getting locked up. It's an opportunity that might help you out, but we'll see how that plays out. I also find that your pleas are knowing and voluntary, meaning you've understood what we talked about. Do you agree with that?
Yes, sir.
And voluntary just means no one's forcing you to enter this
Yes,
plea.
sir.
Okay.
Yes, sir.
Ms. Wood, do you authorize someone in my office to sign your name and your clients to each of the 3 indictments?
Yes, Judge.
Ms. Smith?
Yes, Judge.
Okay. Let me figure out how to pronounce this sentence. So starting with 21 SC 178640, count 1, I'm going to sentence you to 1 year to serve. Count 2 will be 12 months to serve. And count 3 is 12 months to serve. Those will run concurrently with each other. So that's 1 year. I think that sentence is already done because of your revocation. I think the Department of Corrections will view that as that sentence is complete. In 26 SC 000824, this is the July 2025 Chevy Spark case. Which of these has a 10 in it? Is fleeing and attempting to elude is the maximum 10? I'm trying to figure out how you get to 10 to serve 1.
Yes, it's 12 months to 10 years. Like it's 12 months to 10 years.
Okay. All right. Your sentence as to count 1 is 10 years to serve 1 year with a balance on probation. Count 2 is 12 months to serve. 3 is 12 months to serve, same with 4 and same with 5. So that's a total of 10 years to serve 1 year, balance probated. Special conditions of your probation. Number 1, stay away from the red Chevy Spark. Just resist the temptation to drive that because they're going to see you and say, there's Mr. Jordan in that red car. East Point probably has a photograph of you in that car in each of their patrol cars because they're going to pull you over. Number 2, when you are out, you will get a drug and alcohol abuse evaluation. And if they recommend any treatment, that treatment is part of your probation. I'm also going to require that you have at least 3 random drug screens each month for the first 6 months of probation. If you are blowing those up, that'll be a reason to get you into drug court or into the day reporting center, which is another way to get you some drug treatment, some job readiness, things like that. But I'm not going to require those because it may be that when you are out, you aren't testing positive. Finally, in 26 SC 000825, that's the most recent one from February of this year. Count 1, what's the range for that theft by receiving?
1 to 10, but let me double check. I'm gonna say 1 to 10, but I'm verifying right now, Judge.
Okay. I just don't want to give you an illegal sentence because then we have to do it all over again. Yes, it's 1 to 10. All right, so count 1 is 10 years to serve, 1 year, balance probated. Count 2 is 1 year to serve. 3 and 4 are both 12 months to serve. So same sentence, it'll run concurrently with the other case and the same conditions of probation. Stay away from the red spark, drug and alcohol evaluation and treatment. I'm going to waive your probation supervision fees for the first 3 months after you get out so you can get situated, settled, maybe start working. And I think that covers everything. Ms. Smith, anything else?
Nothing further. Thank you.
Ms. Wood?
No, Your Honor, thank you.
Okay, Ms. Simpson, Mr. Jordan needs to report 48 hours after release.
His probation is late, so more than likely, they'll be able to.
Okay, is that where home is, Clayton County?
No, I stay in Atlanta.
Okay, well, when you are released, whatever your home address is gonna be defines where you report to probation. It's the county of your residence.
I probably have to get, my probation transferred, from
Okay, well, they'll train, I mean, you show up to a probation office and say, here I am, Calvin Jordan, and you provide proof of residency wherever it is you're staying, and they'll say, I mean, you could have been in, Cook County, and they'll move it to Fulton if that's where home is.
Yes, sir.
Okay? All right, good luck with things.
All right, thanks, sir.
Bye,
Thank
Mr.
you.
Jordan,
Thank
you're
you.
welcome.
All right, have a nice day.
You too. That was helpful. I couldn't figure out how the red spark kept reappearing in his life. It didn't make sense. Got it. Mom's car. Let's take a mom's car. I'm gonna call our 11 o'clock calendar again because people have been coming in. Travis Christian. Hey, Ms. Lee. I'm well. Have you had a chance to speak with Ms. Smith about the case? Okay, so when we're done calling the calendar, you and Ms. Smith can chat. We'll take a little break and come back to handle that. Ms. Tucker is still ready to go?
Yes, sir.
All right, and Robert Davis is still a plea?
Yes, Your Honor.
All right, and Thomas Smith is Ms. Kim's case. I think that's it. Do we have other walk-ins? I don't think we had other walk-ins. Do we have an update? I don't see Ms. Williams. Ms. Peterson? Hey, Mr. Mullins, who are you representing? Mr. Monis, can you hear us?
Yes, Judge, sorry about that. Maurice Floyd, I'm stepping in for Jennifer Hansen today.
Oh, all right. Well, look at that. And Mr. Floyd is here. I forgot the calendar was at 11. Well, we already handled it in this respect. Ms. Hansen's already filed an entry, so that's good. Mr. Monis is just standing in. And she also filed a waiver of arraignment. So she's entered a plea of not guilty on your behalf, Mr. Floyd. The next thing that'll happen is that Ms. Hansen will get discovery from Ms. Nix, who was in here. That's right there, front and center, from Ms. Nix, the prosecutor on your case. And then Ms. Hansen will talk with you about that. And she'll also start talking with the prosecutor to see what a resolution of your case looks like. Since you're here, I want to confirm we have two different addresses for you. One of them is Terrell Mill Road, an apartment there, and another is an apartment on Buffington Road. Is either of those? Okay, that's a good place for your mail?
Yes, sir.
Apartment 5700A?
Correct.
Okay, that's where the mail will go. So you've got that. Obviously, you have Ms. Hansen's contact information. You've hired her. Anything else, Mr. Monis, on behalf of Mr. Floyd?
No, Your Honor, thank you.
All right, Ms. Nix, anything from the state?
No, sir.
Okay, so Mr. Floyd, you will learn about your next court date from two places. One, Ms. Hansen will let you know, and you'll probably hear from her first, but we'll send in the mail to that Terrell Mill address, whatever the notice is, okay? All right, if you don't have anything else, you're good to go. You're welcome.
May I be excused, Your Honor?
Yes, sir, thank you for joining us.
All right, thank you. Have a good day.
You too. So why don't we take a quick break? People can speak with their opposing colleagues. Mr. Wooten, Mr. Ford gave me the I don't think it's very likely scenario. You're welcome to stay for a little bit. If you leave your 1-800 number, we can call you if Ms. Brown shows up. But I don't mean for you or your investigator to have to sit around a lot waiting for mean, it's not December, so Santa's not coming.
I don't mind.
Okay, all right. Anyone else thought they had a case today? Nope, okay. All right. Let's take a 5-minute break, and when we come back, if there's not an update on Okoro, let's finish. What do you have left?
We have.
I know you have, the plea.
Tucker, Davis, oh, and there is one more add-on, the Woods.
Oh, that's from last week
We
too.
had to go out with a bang for your last.
Wood with Woods, right, okay. We can handle those in whatever order.
Thank you, Judge.
All right, I'll be back in just a couple minutes.
Oh, okay. Okay.
So you wanted to bet?
I am. Ms. Shigley, how late are you able to stay? Yeah, the only Shigley in here.
So it's over.
Okay, all right, I just wanted to be available to chat, if you had questions, depending on when we finish. All right.
When the judge come back, Smith ready.
Awesome.
That's on this way. Wow. Oh. Then you have each other. All right. So it goes on back on. Is it in prison? It's going to.
I think we're ready to just, yeah, whenever he's, I think we've talked to everybody. I guess I can go over one more thing with Mr. Woods while we're waiting.
Here it is. I think it's, oh, it's 20 in a row. Okay. I'm not sure.
Yes, I think so.
Yeah.
Oh, wow. Okay, let me figure out what's going on, because I was on another piece, so I'll get it, let you. You're welcome. Okay.
And then we're. I know there's, it is confusing. I guess I'm going to find it, and then there's all of them from the internet policy. Oh, maybe then there was. In the next. It wasn't. Yeah, you're trying to see what it's going to. That's why. Yeah. So what was it? So that that's what. Oh, I think so. It's gonna stop, so then you guys can help.
Oh, yes, okay.
Yeah.
Oh, Smith. Oh, I thought you. He's for accountability. With your objective. Field record of running. All right. I follow my ask.
The plea negotiated and honored. So they're saying harder and shade because we're taking the house basically. So she's not going to get. I was doing that a little and see what it's at. I'm not going to. When you have a. I'm so sorry. It's okay.
Do we approach briefly? Sure, and then we'll get started. Mr. Peoples, you're not supposed to be walking around. What are you doing?
Walking slow.
Okay, take a seat.
You're okay.
This John, the family wanted it out. I'm on obligation to participation from that meeting. Just send along.
Was that who just walked in?
Scare so you probably had an argument with officer, but you work Friday afternoon, so you don't pay, here you are. And nothing's gonna come. There is no. There's some room for 50 minutes.
Okay.
The reason we're before here, recognize this.
Sure. Do you have an issue with that? Still let him go?
Yeah, she says. I don't know if she's here today, or she's always here.
I get to work with you. Thank you for sharing it.
You're welcome.
No question.
Yes. I hope so. Sure.
I
What
don't,
did Derek,
I mean,
did Derek know that you guys had
I don't know that you need to stick around. I mean, she's not here, so. Okay. Right.
my intern lab summer got
Yeah.
Yeah, Axon, evidence.com was always in my ear. But I'll find out, because that would be very helpful.
Over capital 7.
Sky's the limit.
I'm over capital 7, but that's where I think you're.
Yeah. Right. Okay.
We'll take.
What's the doctor's last name?
I'll go make sure.
Dr. Qureshi? Hey, thank you for being here. I appreciate you responding to the subpoena. We're not going to be able to go forward today with Ms. Brown's situation if she's not here, and it sounds like she's not going to be here. I don't mean to inconvenience you further by having you wait around. I appreciate you being as responsive as you were. I know you've got a host of other responsibilities. This is an important situation, and it may be that we circle back and need to get input from you about it, but I don't know that today we'll be able to because Ms. Brown is declining to accept my invitation to be here today. Okay? Do you need to speak with the doctor at all, Mr. Wooten? Okay. Anything else for Mr. Ford? Okay. Thank you so much for being here. I appreciate your service. All right. Good. All right.
Thanks.
Hold on. Ms. Williams, tell me what you understand we're doing in the Okoro matter, since you've got witnesses on hold and all that.
Your Honor, actually, my witnesses are now in the courtroom.
Oh.
And my understanding is that we are going forward with a non-negotiated.
Okay. We will do that when everyone is present and ready to go, and your witnesses, if they don't mind sitting tight, can sit tight a little bit. I think we'll knock out another Wood or Cobb matter.
Yes.
Sir, you are here for what case?
Mr. Smith, looking for a plea.
Thomas Smith.
Yes, sir.
Okay, you're handling that in lieu of Ms. Kim?
Well, I'm working with this Kim.
Okay, all right, great. So you and she are co-counsel on that?
Yes, sir.
Excellent. All right, we will certainly take care of that. She's focused on a messier situation right now.
Yes, sir.
And Mr. Pierce has been sent back downstairs. So tell me the order in which you'd like to do things, Ms. Wood, until we get Mr. Okoro in here.
Perfect. We'll do position for Robert Davis.
All right.
We'll handle that.
Great.
Okay.
Mr. Davis.
All right, Ms. Watson, we're going to get on the record. This is position 4 on our calendar, State versus Robert Davis, 26 SC 000503. Good morning, Mr. Davis.
Yeah, how you doing?
I'm okay. How are you doing?
So.
So. In your situation, I can understand that answer. Mr. Davis, you are represented by Mr. Cobb, who's standing right next to you. In the prosecution, the state is represented by Ms. Smith. We're going to go forward with your plea. Ms. Smith is going to put you under oath in just a moment and ask you a bunch of questions about you and your case and your rights. You need to answer her questions truthfully and completely.
Yes, sir.
You also need to let Mr. Cobb or me know if you've got any questions, or if whatever we say confuses you, you need to call that time out so we can explain whatever it is we're talking about. Will you do that?
I understand.
Yes, you'll do that?
Yes, sir.
Good. Okay. Ms. Smith.
Today, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Robert Frank Davis Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
I'm on nothing.
Is there any medication that you would normally take that you haven't been given today?
No, everything all right.
How old are you and how far have you gone in school?
I'm 70. I went to night school and finished.
You said you're 70, 70?
Yeah.
And night school, was that high school, college?
It was like, it's over there on Blackcliff Road. It's called Kitcher Adult.
Okay,
I went to night school.
got it.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
I understand.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with his services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
We don't read it. Yes.
Mr. Davis, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
I don't have any.
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 6 months with the balance probated?
Yes, ma'am. I understand.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
I understand.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
I understand.
Do you also understand that this is a guilty plea that is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
I understand.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
I understand.
Counsel, are you satisfied that your client understands that these are the rights they'll be waiving by entering this guilty plea?
Yes.
Mr. Davis, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 26 SC 000503, how do you plead to count 1, theft by taking, count 2, loitering or prowling, and count 3, giving false information, name, address, or birthday to law enforcement officers?
I plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
I understand.
Do you understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you also understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
I understand.
Thank you, Mr. Davis.
Thank you.
Judge, if this case were to proceed to trial, the state would show and the facts would show that on December 3rd, 2025, officers of the Georgia Tech Police Department responded to a be on the lookout BOLO alert that was dispatched to the department. The dispatch informed the officers that an individual's location and clothing prior to their arrival matched the clothing of a person that stole a bike from a residential location. This occurred in Fulton County, and also when the officers were able to make contact with the defendant in this case, he identified himself as Johnny Davis and gave a birthday of March 29th, 1962. The officers checked this information through GCIC but found no records. The officer then at this time radioed for the identity of Mr. Davis, where he was able to find out who Mr. Davis actually was and the date of birth that actually matched who he was. In this case, the officers were responding to a BOLO for a Diamondback and gray and lime green bike that was valued at $300. The officer stated that the victim in this case put his bike on a rack by his residential apartment. But at the time when he went into the home, the defendant in this case did take the bike from the rack that it was double locked to. And the BOLO was put out for the defendant in this case. In addition to the claim that the defendant had taken this bike from the bike rack, the victim in this case, Mr. Maddox, was able to provide video footage from a neighbor's security camera that showed Mr. Davis going to up to several vehicles or bikes, trying to see if they were unlocked and to see which one that he could take from the incident location. But based on these facts, the BOLO and the misidentification that the defendant gave to the officers on the day in question, the defendant was arrested for the crime, for the charges we have in front of us. Regarding the negotiated plea between the state and defense, we've agreed to a sentence of 5 years to serve 6 months with the balance to be probated. Regarding the special conditions of probation, the state is asking for the defendant to stay away from the incident location, for the defendant to complete an anti-theft course, to be gainfully employed, to have no contact with the victim, and to complete a drug and alcohol abuse evaluation with treatment if necessary. In this case, the state was going to ask for 40 hours of community service. However, in my recommendation, I stated that if the defendant was to pay restitution for that bike, which is $300, without that restitution hearing, then we would not be asking for the 40 hours of community service. But that is all from the state, Your Honor.
Okay, you're saying if I impose restitution, don't do community service. If I don't impose restitution, do put the community service in?
Correct.
Okay. And did Mr. Cobb give you any reason to believe that Mr. Davis was in a position to pay that restitution?
No, Your Honor.
Okay.
I said that because when I spoke with the victim, this happened a while ago, and his main concern was that this was a bike that he loved, that he, had for a very long time, and he just wanted to be able to replace it. So his main concern was not having Mr. Davis in jail for a long period of time, but to actually be able to get the restitution for his bike.
Got it. Okay. And is the bike owner a student at Georgia Tech?
I'm not too sure about that.
Okay. All right. Thank you. Ms. Smith-Mann, criminal history information on Mr. Davis, please.
Yes, Your Honor. This is a multi-state offender for Georgia and the state of Florida. There are no felony arrests in Georgia, not including the case that is before you. That arrest is not listed on our GCIC as of yet. There are 4 convictions in Florida for felony and 1 conviction for misdemeanor in Florida that ranges from 2008 through 2023. Nothing further, Your Honor.
Okay. You may have bumped into a different Robert Frank Davis. I've got in front of me the repeat offender notice from the state, and they have him down with 7 felony convictions. All of them are pretty old, from Fulton County, burglary, entering vehicle, things like that. So I'm wondering if Mr. Davis in his 7 decades on the planet has maybe made it kind of hard to track him on the GCIC. Okay. What case is he on probation for?
Or SC 00424.
That fits more with what Ms. Smith-Mann is saying, because that's a more recent conviction. There's nothing like that on this notice. But it sounds like he's been arrested a few times. Okay. Do we need to deal with revocation? Okay. And what was the result?
60 days are reinstated before
Judge. Oh, okay. All right. Mr. Cobb, what do you want to tell me about your client and his situation?
Well, Your Honor, this was not Mr. Davis Jr.'s first rodeo, and he recognized that, and now he's ready to be accountable and go forward with starting over his life. He did complete adult high school at Kittredge Adult Learning Center here in Atlanta. Is actually very excited about being a grandfather and believes that accepting this offer today will help him get on the right track. So we agree with the state. This was negotiated and would like Your Honorable Court to recognize it.
Mr. Davis, do you have a place to stay when you get out?
Yeah, I'm gonna stay with my brother.
With your brother?
Yeah,
Okay, what county is that in?
in Fulton County.
Okay.
I got a job and everything waiting on me.
What kind of work?
I work at the Salvation Army
Great.
in the warehouse.
So address I've got for you is an apartment on Peachtree Street. Is that your brother's place?
Yeah,
And there's room for you there?
yeah, he got a 2-bedroom.
Okay. Is he an older brother or a younger brother?
My young brother.
Okay, and he's willing to take care of you a little bit?
Until I get my Social Security started.
Great. Well, you're fortunate to have a brother like that. Does he work?
Yeah, he like he work at Walmart.
Okay. And his apartment's got room for you.
Yeah, I'm just gonna stay there maybe a couple months till I get my own
It's
place.
just good to just till you get situated.
Yeah, that's right, sir.
All right.
I'm sorry, but I'm gonna be successful in the grandfather business.
Is this your first grandkid?
And I got I got three granddaughters.
Okay, and you have a brand new one, or you're just ready to get out there and be grandpa?
I just want to get out.
I'm sure you want to get out. Are your granddaughters here in Atlanta?
Yeah, yes, sir.
Okay. Do you have any questions about anything we discussed?
No, sir, I'm good. I just want to get some church chicken.
Not Popeyes or KFC?
No, strictly church.
You're a Church's guy.
Yeah,
Why Church's?
it's cheap.
It's cheaper. Okay. Well, that may tell you something about the chicken, but if that's what you want, you should get it. Where are you going to get money to go to Church's?
I'm gonna get some from my brother right now.
Okay. All right.
The food stamp.
Make sure you get it from a good spot. No more bike stealing, okay?
I'm gonna be all right.
Well, it's just while you are young, you're not as young as you used to be. And getting locked up is going to take a toll on you.
I know.
And guess who you're not around if you're in jail? Your granddaughters. So your desire for Church's chicken needs to not get you into trouble, all right?
Yes, sir. I'm gonna make better decisions in the future.
Got it. Well, Mr. Cobb said you're ready to restart, so hopefully you are. Mr. Davis, I find there's a factual basis for your plea. You took a bike that wasn't yours and it ended up being an important bike to this person. I also find that your plea is knowing, meaning you've understood the things we talked about, and your plea is voluntary, meaning no one's forcing you to enter the plea. Do you agree with that?
Yes, sir.
Good. Mr. Cobb, do you authorize someone in my office to sign the indictment on your behalf and your client's behalf?
Yes, Your Honor.
We'll do that. Ms. Smith, can we sign for you? Mr. Davis, I'm going to sentence you to 5 years to serve 7 months with a balance on probation. Special condition number 1 is that you stay away from that address on Calhoun Drive. Number 2 is that you have no contact with the bike's owner. I think that's a stranger to you, but don't look him up to say, hey, I'm sorry I took your bike, or I'm going to do it to you again. Leave that person alone. Number 3 is that you will submit to a drug and alcohol abuse evaluation. And if that expert, that good medical professional decides that you'd benefit from some kind of treatment because of drinking or smoking or something that's not healthy for you, that treatment will be part of your probation. And finally, I'm going to require that you do 40 hours of community service. You need to get that evaluation that I just mentioned within the first 3 months of probation, and you need to do your 40 hours of community service within the first 4 months of probation.
You know, I've been locked up since December 3rd. Do I get all of my jail time?
You do. You have 1 more day to serve. You will have served 7 months tomorrow. My guess is you'll get out tomorrow. But you are entitled to all the days you've been in. You will get out. And I'm going to waive your probation supervision fees for the first 6 months. So you can get your benefits back in place, maybe doing a little work at Salvation Army, et cetera. Okay?
Yes, sir.
All right. Hope you make good choices when you get out and enjoy that Church's chicken. Mr. Cobb, anything else on behalf of Mr. Davis?
Nothing else, Your Honor. Thank you.
Ms. Smith?
Did we address restitution?
We did, and given Mr. Davis's financial means, my thought was to do the community service in lieu of that. It sounds like his primary stream of income will be SSI or SSDI, and rather than diverting, it's not to minimize the victim's loss, but that's an inefficient way to do restitution. So I'm not ignoring it at all. I think it's a question of means here. Okay, sure. Mr. Davis, last thing. This young lady here in the purple and green is going to come talk to you. She's with probation. She's going to give you reporting instructions. Do not miss your appointment. Because you're getting out tomorrow, you're probably going to get a specific appointment. Don't miss that, because if you do, they're just going to send me a warrant and then you're getting locked up again, okay?
Yes, sir.
All right. Good luck.
I'm gonna be a good guy.
Good.
Okay.
A good old guy.
Thank you. Best of luck to you, Mr. Chairman.
Oh, hold on. Sorry, I didn't give you your complete sentence. I was focused on count 1. Count 2 is 7 months to serve, and count 3 is 7 months to serve. So it's still 5 years to serve 7 months on count 1, and the other 2 counts will run at the same time. Okay? Thanks, Ms. Simpson. You want to come join the family division so I complete all my rulings there too?
different.
It's like he didn't give custody to the second kid. This kid has no parents. All right, Ms. Lee, are you ready to go with your revocation? Okay, you ready to handle that? Okay. We can bring Mr. Christian out when you guys are ready. And Ms. Kim, Ms. Williams told me she believed that your matter with Mr. Okoro is ready for a non-negotiated plea. Is that correct?
Yes, sir.
Okay, we're gonna take care of a couple more things with Ms. Wood, who needs to get out of here, and then we'll turn to that.
Okay, my colleague, Carlos Michu, will be handling Thomas Street.
Yep. He already asserted himself on that one. So we'll do Ms. Tucker right after Mr. Christian.
Yes. Thank you, Judge.
Sure. Hey, Mr. Christian, if you come stand next to Ms. Lee, please. All right, Ms. Watson, we're going to get on the record. This is position 1 from our probation revocation calendar. It's 11 SC 103008. State versus Travis Christian. Mr. Christian is here in court with his attorney, Ms. Lee. Ms. Smith is representing the state. Mr. Christian, you've got 3 years and 19 days left on one of the world's longest probated sentences. This must have been with Judge Downs.
I believe it
Okay,
was, Judge.
all right.
Yes.
Given the duration of the sentence. And Mr. Christian, you're here because just over a year ago, I signed a probation warrant that indicated that you had picked up new charges in DeKalb for forgery. I'm going to ask Ms. Lee to talk to me about whether you are challenging that or if you're stipulating to the arrest or maybe you've even resolved it, but she'll tell me about that. I'm going to let her give me a recommendation as to what should happen with your probation. Then I'm going to hear from Ms. Smith, the prosecutor, as well as Ms. Simpson from probation, and we'll figure out what's happening, okay? Yes, sir. Great. Ms. Lee?
Good morning, Your Honor. Thank you. Your Honor, Mr. Christian was arrested on 4/15/2025 in DeKalb. We are stipulating to that arrest, Your Honor. The case remains unindicted as of last night when I checked. It stemmed from a traffic violation, Judge, and my understanding is that there was an issue with the license. I don't know exactly what, but we are stipulating to that arrest, Judge. Since the last time we were before you, you may remember that you ordered Mr. Christian to complete some drug treatment at Georgia Recovery Centers. He did enter a 12-month-long intensive outpatient treatment, and he successfully completed all of that, Your Honor. I've spoken with the state and probation, and they have recommended that you revoke 60 days and terminate the balance, and we're asking that you follow that recommendation, Judge. Mr. Christian's wife is here in the courtroom in support. And just a little bit about him. He's been in custody 67 days. He works for Ms. Myers' company. It's Myers Assessment and Therapeutic Services. They offer applied behavioral analysis, early intervention, and educational support services for children with special needs. Mr. Christian is the billing specialist for that business. He also does janitorial work, cleaning and maintaining both. They have 2 clinics, both of those clinics. He has also, with his, I believe, brothers or cousins, opened a trucking company. They have a couple of trucks. He's able to do the logistics. So he is working. He's been in complete compliance with probation. He notified them of the new arrest. And
I believe he was turning in his some completion documents when he was taken into custody.
Okay.
So we are asking that you follow the recommendation of the state and probation.
Got it. Okay. Ms. Smith?
Yes, Judge, the state is asking to revoke 60 days and terminate the balance. It's my understanding that the defendant has another case that he's been supervised for the same amount of time he has left in his case. So that's why we're asking to terminate the balance in this case here. Because the treatment program was completed after his legal arrest, I want to give the defendant in this case a chance to show that he would take probation seriously. I did let the defense counsel know that the defendant asked for more time. But because of the circumstances here, the fact that he has to leave that treatment program, we're just asking to revoke 60 days and terminate the balance.
Okay. Ms. Simpson?
So the basis for the recommendation was that, I took into account that he considered that he was drug court, graduate. And then aside from he did pick up a new conviction in Tennessee for possession of cocaine. He was sentenced to, I believe, 5 years total probation. He also, his balance in Tennessee is the same as what it is here. He was revoked for that here, in March of 24. Judge, you revoked him the 30 days into drug recovery. He completed that, successfully. I sent you the certificate as well as training needed actually also provided. I took that into account as well. He's taken the initiative to seek some help for his substance abuse. And so with that, it's why I think yes, for 60 days terminated. We are currently asking for this case.
Okay, that was my question for you was, what's this other case? And it's out of Tennessee, but through ICOTS, your DCS is managing that. And that's the coverage we've got for Mr. Christian as he moves forward. Got it. Okay, understood. Thank you. Mr. Christian, any questions about any of that?
No, sir.
Okay, so it sounds like you've got a bunch of lines of work. What is the one where you spend the most time?
Myers Assessment and Therapeutic Services.
All right. Well, Mr. Christian, because you've got probation out of that Tennessee case, which is much newer and the probation is a little more relevant to those allegations, I will revoke 2 months of your probation on the 11 SC case. You'll get credit for the time you've been in custody, and I will close out the balance. Is the term terminate the balance or what? So I'll terminate your probation in this case from 2011, okay?
Yes, sir.
You should get out soon. You should stay focused on your recovery and do your best to stay out of trouble, all right?
Yes, sir.
Good luck with everything.
Yes, sir. Thank you.
Where's your wife? Right there. All right, you'll help keep him heading in a good direction? Good. You ready for him to get home? Okay. You better be on good behavior when you get home.
Definitely.
Okay, all right.
Your Honor, that's all I have. May I be excused?
Yes, ma'am, thank you for your time.
Thank you, Judge. And may I go back and speak with Mr. Christian just a minute?
Sure, you go with Ms. Simpson. All right, so Ms. Tucker and then Mr. Woods.
Yes, Judge.
And then we will do Mr. Okoro.
Thank you for accommodating me.
Sure. Is there a plan for Ms. Tucker? She's kind of exhausted all plans.
I'll explain.
Okay. Mr. Wooten, your optimism impresses me.
I just like kind of being, I don't know.
In a courtroom
Sure.
where you're not front and center.
I don't know if that even makes sense. I get a lot of that.
A body would come in here, bring his laptop and sit in the corner. He's like, shh, just, it's good. Don't tell anyone I'm here. And he would power
I
through
would
stuff.
say that, but something like that.
Mr. Woods is just one case? Two cases. You
We'll
guys
be
are
quick
taking
though,
such
Judge.
good care of Judge Ellerby. I don't know where you were when
I have
they were
closed
my
out
case.
25 cases this month, so.
Beautiful thing. Hope
Thank
my
you.
name shows up on that when it happens. All right, let's get on the record. This is position 3 on our probation calendar, 24 SC 005883, State versus Tucker. Good morning, Ms. Tucker.
Good day, Your Honor.
Good to see you.
Good to see you too.
Sort of good to see you. It's always good to see you, but we have some talking we need to do.
Yes, sir.
Ms. Tucker is represented by Ms. Wood, who's here in court with her. Ms. Smith is here for the state. Ms. Tucker, we are together because in December, just before Christmas of last year, I signed a warrant that alleges that you were terminated from Gilgal. You didn't go to Ruth's place and you hadn't been following the different conditions that we all agreed were there to help lift you up rather than hold you back. This is not the first program that didn't work out. So we need to figure out what's next. You've got just under 3 years remaining on your probation, okay?
Sir.
Ms. Wood, is Ms. Tucker admitting to these allegations?
She is.
And what are you proposing we do?
So, Your Honor, when we requested the reset back a few months ago, it was based on, but my understanding was that she had self-terminated from the program because she had some medical issues that needed to be treated, and the program felt that they couldn't facilitate it. And so I asked Ms. Ross to reach out and see if they were willing to work with her, given that perhaps she had taken care of those medical issues. Ms. Ross reached out. They were able to say, yes, we would take her back, but we need to do an intake interview. And at that point, the program went to meet with Ms. Tucker to qualify her, and
The program is Gilgal again, or it's a different?
it's Women on the Rise, and so they were going to reevaluate her to see if they had a different connection that maybe was a better fit. It's my understanding she was with Gilgal and a different program of theirs called Antioch.
Yes.
Okay.
They're the one payment of one.
And then there's also the mention of the Ruth's Place program as well, Judge. But it's my understanding that Ms. Tucker met with them recently.
Them meaning Women on the Rise.
Yes, Judge. And she shared with them that she felt like she did not need their services. And so here we are today. She's asking the court to revoke 3 months of her probation. She has shared with me that she's gainfully employed. She works for a trucking company. She also shared that she is clean and sober, and that she feels like it is in her best interest to be able to be gainfully employed. She says that she's willing to make probation payments, and having that structure is what she feels is best for her to stay clean and sober, Judge. So that is our request of the court.
Got it. Ms. Tucker, where would you stay?
Yes, sir. I would live with my mother, Faye Tucker. She just moved in Stone Mountain. She moved from where Mrs. Officer Smith came to see me over off of Myrtle Drive and Campbellton Road in a senior citizens facility. But it was just a lot of drug activity there. And so I went back to where I was, and I'm no longer there because it was with my godmother. I told her, too much people, places, and grounds. I care not to be there anymore. That's off of Bankhead over near the truck stop Petro. That's the area. I'm no longer, I don't even go that way. When we go to gas up, we go up the exit. And so I just, I did my I looked at myself and, that job was helping me with my mental health. I was taking my medications and staying out of the area, staying off from around law enforcement, not using no drugs, no alcohol, and I have cirrhosis of the liver, so I'm definitely can't. I don't want to die in that situation like that. I have my 7th grandbaby about to be born next month, yes. And so that brought me closer with my mom, my kids. And I finally got a chance to see my grandkids that I hadn't met, because their parents, I did not feel bad about it because they didn't want me around them under influence. So now I get a chance to be with them.
Tell me about this job you have.
Yes, it's through DBA and Fox Carriers out of the airport. I had just got off line with a meeting, a NA meeting. And I was on Craigslist and I found it and I talked with the guy and I went out to Doraville to do the invitation. And so they asked me, do I read, write, spell good? And I said, yes, sir. And so he asked me, would I like to travel and do, I bid loads with load wrecks and I put the information on paper, and I put the information on paper and in the cell phone on Waze for directions. And then I call load wrecks and let them know, and I have to take pictures of the load and the paperwork and send it back to DBA at the airport and Fox Carriers.
Okay.
Yes, sir.
Do you have the name and contact information of someone that Ms. Wood or her team could reach out to so I could see verification that that job is still there for you?
Yes, it is.
Okay.
Yes. Who should I give her?
No one right yet. I just want to know that that is something that you're able to do.
Yes, sir.
Okay. All right. Thank you. Ms. Smith.
Yes, Judge, in this case, the state will be asking to revoke 6 months and to reinstate the balance upon the defendant entering ITF, the intensive treatment facility. We're asking to revoke those 6 months because we want the defendant to get help, but kind of wanted to be to make sure that she's able to be released or transported to this program and that she will participate. So because of that, we're asking for the 6 months to revoke.
All right. Ms. Simpson.
Yes, Judge, so ITF was our application, of course, given that, after the defendant was terminated from Yodale, our officer made several other attempts to seek some outside additional treatment, and every time she submitted a referral, the defendant was not compliant to it. So ITF is the best way that we can figure she can get a treatment without being qualified.
And remind me, did Ms. Tucker, were you in drug court for a little bit and drug court didn't work out, or?
I don't think.
I've been
we've
in
tried-
drug court and I successfully finished drug court. This was 2012.
A long time ago.
Yes.
Okay. Not more
long-
recently.
Long time ago,
Okay.
yes.
Understood.
When
Okay.
Judge Downs was
Oh,
the
yep.
judge. Yes.
Back in the golden era.
Oh, yeah.
So here's what I'm going to do, Ms. Tucker. I need to get confirmation from your supervisor, boss, whatever you want to call the person,
Yes.
from DBA, Fox Trucking, that there is a position for you that you can go to should you be released shortly. That'll help me figure out whether I go with the let's plug you back in with your family and a job that I know you have and a place you can stay, which is with your mother in Stone Mountain.
Yes.
Or if we get you treatment that you can't walk away from, because I know that a number of folks who have wanted a good outcome for you have tried to structure this so that you get treatment. And for whatever reason, some of them may have been medical reasons. Some of them may have been, that's not the right treatment for me. You haven't received it. And in the end, we're not helping you be the grandmother you want to be and the mother you want to be and the daughter you want to be if we're leaving you unequipped to deal with the stressors of that role in life. And if the way you treat those stressors, as in you manage them, is to use things you shouldn't be using, we're just repeating the process all over again. And that doesn't help anyone, you in particular. I'm going to ask you to share with Ms. Wood how to verify that employment situation. And if she's able to do that and get it to me and Ms. Smith, then I'll handle your revocation in one way along the lines of what Ms. Wood advocated for. But if in the end that turns out to be less of an option for you, then I've got the state and DCS's recommendation, and I can work with that. Okay? Does that make sense?
Yes.
Okay, so you'll get that information to Ms. Wood.
Yes.
Okay, there's not a rush. I'm not going to go do it right now. I want to give Ms. Wood a chance to do that. Just we won't need to bring you back here because I will either do a revocation that gets you out in a few days so you can do the things that you've described that sound very positive,
Yes, sir.
but are linked to you having gainful employment and a place to stay, or I will follow the state's recommendation and get you treatment, which connects you with your family, not as soon, but gives you the tools you need so that when you do reconnect with your family, you'll be have a much stronger basis to maintain your sobriety. Okay?
Yes, sir.
All right. Thanks.
Thank you, Judge. All right, I'll call your mom. Okay.
Okay.
All right.
Yes.
Can we do Mr. Woods now?
Yep. Do you have his case number?
Yes. So the first one is 26 SC 000344. And the second one is 26 SC 003288.
All right. We'll take those two, please, and then we'll get Mr. Okoro up here.
Okay. The last plea ever in 8D.
Oh.
Savor it. Good morning, Mr. Woods.
Morning, Judge.
Mr. Woods, Ms. Wood tells me that you are ready to enter pleas in your two cases. Is that correct?
That's correct.
Okay. Ms. Smith, who is seated to my left, is going to put you under oath in just a moment and then ask you about your cases and your rights. Please answer all her questions truthfully and completely. And please also let me or Ms. Wood know if you have any questions. Will you do that?
Sure.
Okay. And I should have prefaced with this, but Ms. Watson, we're on the record. Ms. Smith.
Thank you, Judge. Mr. Woods, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can lower your hand. Please state your true, correct, and legal name for the court.
Brian Lamar Woods.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
I am not.
Is there any medication that you would normally take that you haven't been given today?
No.
How old are you and how far have you gone in school?
I'm 53.
How far have you gone in school?
I'm a graduate at DM Darrell High.
Are you able to read, write, and understand the English language?
I am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
I do.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in the indictment and accusation?
I have.
Do you need more time to discuss your case with your attorney?
Do you have a question
Yeah, I
you
did
good?
need to speak with you.
outside of what we already talked about? Okay, so you need time right now?
Yes.
All right. Judge, I'm not sure what his question is.
Okay.
Go over there.
Okay. Mr. Woods, you had the time you needed to speak with Ms. Wood?
Yes, Your Honor.
Great.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waived.
Mr. Woods, do you remember being arrested on these charges?
I do.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
We are not.
Do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
I do.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
I do.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, I do.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
I do.
Are you a United States citizen?
I am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
I do.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
I do.
Counsel, are you satisfied that your client understands that these are the rights they'll be waiving by entering this plea?
I am.
Mr. Woods, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No.
As to indictment number 26 SC 000344, how do you plead to count 1, burglary in the second degree, count 2, possession of tools for a commission of a crime, and count 3, theft by taking?
Guilty.
As to indictment number 26 SC 003288, how do you plead to count 1, theft by receiving stolen property?
Guilty.
Is this guilty plea freely and voluntarily given?
Freely.
Let me repeat that. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
I do.
Do you understand that process must be completed within 30 days from today?
I do.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
I do.
Thank you, Mr. Woods. Judge, if this case were to proceed to trial, I want to start with the case ending in 3288. But if this case were to proceed to trial, the facts would show that on September 30th, 2025, officers with the Atlanta Police Department got a call from they got a call from Reinhardt Firms. That location is 2176 County Line Road Southwest in Atlanta, Georgia, also in Fulton County. The report was about a stolen U-Haul truck. So this is a facility that rents out U-Haul trucks to different users. When the officers got there, they said that there was a client or a customer that came to get a U-Haul truck previously, and they returned it. However, the U-Haul truck was no longer there. So they were reporting a stolen U-Haul truck. They did their due diligence by calling the person who rented out the truck, and they confirmed that person did indeed drop the U-Haul off. It just wasn't there anymore. So at the time, the officers did put out a BOLO report for that U-Haul, and that U-Haul was found on the same day that the defendant was charged with the second indictment ending in 0344. And in that case, if the case were to go to trial, the facts would show that on October 6, 2025, officers of the Atlanta Police Department responded to a business burglary at 4485 Campbellton Road, Atlanta, Georgia, also Fulton County. The name of that business is Rahims, that's RAHIMS, Fish and Variety Store. When the officers got there, they spoke with the owner or a person who works there, who stated that on surveillance, it was shown that a person who was later identified as the defendant in this case took a brick to break open or smash the side door after trying to pry it open with a screwdriver. So when that didn't work, they smashed the side door with a brick. They went inside of that establishment and went into the register and stole cash, like starter cash for the day, so around $200. They also stole some food items, which were like French fries and fish, but a variety of fish, so like whiting, tilapia, things like that. They also the defendant in this case went to the back of the office where they searched around and tried to see if there were anything else that they could find. And this was on surveillance footage. The officers were able to look at the footage. They saw the clothing this person had on, what they looked like, and kind of simultaneously when they were responding to this business alert, the U-Haul truck was flagged down as being a part of the burglary. So the officers then went to that location that the U-Haul truck was parked at, which was 3762 Campbellton Road, so right down the street, also in Fulton County. When they got there, they identified the driver as being the defendant in this case, matching the same description as the person who was on surveillance camera during that business burglary. At that time, the officers found the food items in the car. They found the fish and fries that they returned to the store. However, I did speak with the victim in this case who stated that they couldn't use it. They couldn't sell it.
I hope not.
And she stated they did not get all of the items back, but they did get some of it. The officers also found the tools for the burglary, so the screwdriver and things of that sort. Because of the facts we have in front of us, the defendant was arrested for both of these charges, or both of these indictments that kind of go hand in hand. The U-Haul truck that was stolen from the business from the first indictment was then used for the business burglary that we have in front of us.
Got it.
Regarding before I go there, I did speak with the victim in this case who told me that one of the biggest concerns for her was contact with the defendant. She said since the defendant has been arrested, members of his family have come to the store threatening to kill her husband, and her family. They would come in and say things like, "You got my uncle locked up, it's your fault," indicating that they are a part of his family and that they're there on his behalf. So she wanted me to explain to the court that if anything, she just wants to make sure that her business and her family is protected because that is an issue for her. But outside of the victim contact, the state is asking for 5 years to serve one as a global offer in both of the indictments. We're also asking for the defendant to complete an anti-theft course, to pay restitution, which will be reserved. We will file a motion for restitution for the defendant to be gainfully employed. And the last time I had opportunity to speak with Ms. Wood, I believe she said he was either accepted into Salvation Army or will work with PAD. I know PAD cannot be a special condition. So if he's accepted into Salvation Army, we would just ask that he successfully enter and complete the program. And then if PAD, we would just recommend it, not as a special condition of probation, obviously. And then that last thing, no contact with the victim or her family, but that is all from the state.
Okay, thank you so much. Ms. Smith-Man, criminal history information on Mr. Woods. I don't know if you have if you got any of his identifiers. He wasn't on a calendar you received.
I did not, Your Honor. I apologize.
No, that's not on you. Today is a complicated day on this end, and I don't envy you because you didn't get a whole lot of paperwork from us. But you are good to go. Ms. Simpson, do you have Mr. Woods as on probation or having been on probation?
He is not on probation. The last conviction we have is from November 2009.
Okay. Ms. Wood?
Thank you, Judge. Mr. Woods is 53 years old. He is a lifelong resident of Atlanta. He has one child. She's an adult daughter. He is a high school graduate. The last work that he did, he worked at a factory and then he's done some landscaping as well. We did refer him to the PAD program just to help with housing and hopefully get him back on track, Judge. He's been in custody since October 7th of last year. So that is the only part that we're non-negotiated on. He's asking the court to consider 5 served 9 months balance probated. And that's all we have.
Got it. Okay. Mr. Woods, tell me, how much family do you have in the Atlanta area? Pretty much all your family?
Mom, dad, daughter, sister.
Okay, great. And then you have a kid?
She's grown.
She's grown?
Yes.
Is she not in the Atlanta area?
Stone Mountain.
Stone Mountain, close enough. Okay, she's local-ish.
Yeah.
All right. Any questions about anything we've discussed? You understand you'll need to stay away from the fish and variety store.
Yes.
And your family's gonna need to stay away from there as well. I mean, they can shop there, but if they have any kind of interactions with the owner or her family that the owner senses is hostile or critical, that's gonna actually be a problem for you, even though it's your family doing that. So you're gonna need to help your family dial it down a little bit.
Understood.
Okay. Well, Mr. Woods, I find there's a factual basis for your plea in both cases, and that your pleas were knowing and voluntary. Voluntary meaning no one's forcing you to enter the plea, and knowing meaning you've understood the things we discussed. Do you agree with that?
Yes.
Okay. Tell me what your plans are for getting back to work when you get out.
I'm thinking about opening up a landscaping manicurist business.
Okay.
Landscaping. I worked at Georgia Tech, GK2. I have a little experience there, so I'm trying to open up my own business.
Okay.
Small
Right.
business.
Hope that works out. Ms. Wood, can someone in my office sign the indictment on your behalf and Mr. Woods's?
Yes, Judge.
I guess it's one indictment and one accusation, but both of them.
Yes.
Ms. Smith? Okay, we'll do that. Mr. Woods, I'm going to sentence you in the U-Haul van case, which is 26 SC 003-288 to 5 years to serve 1 year with the balance on probation. You'll get credit for all the time you've been in. Special condition number 1 is stay away from the U-Haul rental location. And number 2 is that 2 months into probation, you need to be working at least 10 hours a week, or you'll need to do 10 hours of community service each week. So first 2 months, you're going to get back on your feet, figure out what you're doing. But at that 2-month mark, you need to be working at least 10 hours a week. So that's like a part-time job. And if you can't document that you're working 10 hours a week, then you'll need to do 10 hours of community service each week until you start working at least 10 hours a week. In your other case, 26 SC 000344, your sentence as to count 1, which is the burglary count, is 5 years to serve 1 year, balance probated. Count 2 is 1 year to serve. Count 3 is 12 months to serve. Those will all run concurrently with each other and concurrent with your other case. Special conditions in the case ending in 344 are: number 1, stay away from the fish and variety store on Campbellton Road. Number 2, no contact, direct or indirect, with Ms. Duriasa, that's the owner, or her family. Direct contact means you're contacting them. Indirect would be you have a cousin, a nephew, an uncle going in there saying, you're in a lot of trouble because you made my uncle, my brother's life unpleasant. That family needs to leave them alone. And then that same condition that you heard me mention, which is 2 months into probation, you need to be working 10 hours a week or you'll be doing community service. Yes, sir.
I already have options for security. No, unarmed security.
Okay, that's great. If you're working, then you don't need to worry about the community service. It sounds like you may start your own business. You don't have to do that right away. You could be doing security. That's great. As long as you are logging 10 hours a week, once we get 2 months into your probation, then you don't need to worry about the community service.
Okay.
All right?
Right.
Ms. Smith, anything else on behalf of the state? Reporting instructions for Mr. Woods. Do you know where you'll be staying when you get out? Well, I guess that's a little ways down the road, so we don't need to worry about that. You're going to get a piece of paper. You're going to get it right there. That gives you reporting instructions.
Thank you, Judge.
You're welcome.
I'll come talk to you in the back.
I will see you tomorrow.
Debbie, please.
Yes, ma'am.
Thank you, Judge.
I'd say enjoy where you're going, but it's not necessarily an enjoy thing. Ms. Kim, if you and Mr. Okoro could come up, please. And Ms. Williams, if you don't mind, since our court reporter is virtual, if you could come to the witness stand.
Certainly, Judge. Thank you. I think so. Stand.
Yeah, let's start up there. If it ends up taking too long or you all need a break, you can always take a seat at council table.
So Judge, today's just the plea, right? We'll do the
Correct.
sentencing.
Well, it's plea plus. We have several family members who may want to be heard today in person, so that they aren't speaking virtually at the sentencing. 100% their call. But that's just giving them an opportunity on the record to say what they want to say about their own experiences, and how the allegation in the indictment has affected them. But no sentencing today. Sentencing will be at a date that Ms. Williams and you and Mr. King agree upon. There may be people who want to be here on behalf of Mr. Okoro, and I'll hear from them. But most importantly, it would be to get Mr. King back from the islands.
It is his wife's birthday, Judge. Her 50th.
Okay. Let me know, Ms. Williams, when you're ready.
I'm ready.
You're ready. Okay, let's get on the record. This is indictment 24 SC 004749, State versus Victor Okoro. Mr. Okoro is represented by two attorneys, Ms. Kim and Mr. King. Mr. King is unavailable today, but Ms. Kim is here on his behalf. Ms. Williams is representing the state. Mr. Okoro, today we're just going to talk about your plea. We're not going to get into sentencing. But it does require you to be put under oath. Ms. Williams will do that in just a moment. She will then ask you the questions you've heard other prosecutors asking people all morning, but this will be your turn to answer the questions truthfully and completely. If at any point during our conversation you need to speak with Ms. Kim privately, or you've got questions for her or for me, will you let me know that?
Yes, sir.
Okay. Ms. Williams.
Thank you, Your Honor. Mr. Okoro, please raise your right hand. Do you affirm that the testimony you shall give in the matter currently before this court shall be the truth under penalty of perjury?
Yes.
Thank you, sir. You may go over here. Could you please say and spell for the record your full legal name?
Victor Okoro, last name is Ocoro.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medication that you normally take that you have not been given today?
No, ma'am.
How old are you, sir?
46,
What is the highest level of education that you have completed?
high school.
Do you have your GED or diploma?
Yes,
Are you therefore able to read, write, and understand the English language?
yes,
Ms. Kim, on behalf of your client, do you waive formal reading of the indictment?
We do.
Mr. Okoro, do you understand that you are charged with the offense of child molestation?
yes,
Have you had an opportunity to review or discuss with your attorney the rights that you are giving up by entering a plea of guilty today?
yes,
Have you had enough time to speak with your lawyer, Ms. Kim, and or Mr. King about all the facts and circumstances known to you regarding the charges in the indictment, including any potential defenses?
yes.
Do you need more time to discuss the case with your attorney, Ms. Kim, who is present in court?
Not at this time.
Are you satisfied with her services?
Yes,
Are you satisfied with the services of Attorney Kamani?
yes,
Ms. Kim, on behalf of your client and for the purposes of this plea, do you waive any and all defects in the indictment, including any with respect to his name?
We do.
Mr. Okoro, have you been arrested on these charges?
yes,
Ms. Kim, the state is unaware of any outstanding warrants related to these charges. No of any.
No.
Mr. Okoro, has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
yes,
For the record, the sentencing range for child molestation is 5 years to 20 years. Do you understand that if you are pleading guilty to a crime against a minor, including kidnapping, false imprisonment, or conduct of a sexual nature involving a minor, or if you are pleading guilty to a dangerous sexual offense as defined by state law, you will be required to register as a sex offender?
yes,
Do you understand that if your guilty plea is a blind plea, also called a non-negotiated plea, the state may still recommend a sentence to the court?
yes,
Sir, are you aware that the state previously offered that expired Friday, a sentence of 20 years with 5 to serve?
it was mentioned, yes,
Are you aware that prior to that, the state had offered 20 years with 7 to serve?
I wasn't aware of that one.
That particular offer expired in 2025 at your final plea hearing. Have you had a chance to discuss the offers with your attorney?
Yes,
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
yes,
Do you understand that if you enter a non-negotiated plea, you do not have a right to withdraw your plea once the sentence has been announced?
yes,
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
yes,
And, Your Honor, for the record, the state is not making any recommendations. We are referring to the court for this. But I did want to make sure that the offers were placed on the record.
You're not making any recommendations today, or when we get to sentencing, you envision simply saying, sentence how you will?
Yes.
The latter.
Yes.
Okay. Understood.
Sir, are you on probation or parole?
no,
Sentencing, as you've heard, the judge say, will not be today. However, I do want to go ahead and read you this warning. Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
yes,
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
yes,
Do you understand that you are not allowed to possess or use a firearm while on probation?
yes,
Are you a U.S. citizen?
no,
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
yes,
Do you understand, sir, that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, and or your right to receive, possess, or transport a firearm.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes.
I'm now going to go over the individual rights that you are waiving. Do you understand, sir, that you have the right to plead not guilty?
Yes.
Do you understand that if you plead not guilty, this matter could proceed to trial?
Yes.
Do you understand that by entering a plea of guilty, you waive any and all offenses, including but not limited to any mental health offenses or any assertions of self-defense?
Yes.
You understand that by pleading guilty, you are giving up each of the following rights. Sir, do you understand that you are giving up the right to trial by jury,
Yes.
as well as the right to remain silent and not incriminate yourself,
Yes.
as well as the right to confront witnesses against you,
Yes.
as well as the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes.
as well as the right to the presumption of innocence,
Yes.
as well as the right to testify on your own behalf and to present other evidence,
Yes.
as well as the right to subpoena witnesses and compel the production of evidence,
Yes.
as well as the right to have the charges against you proved by the state beyond a reasonable doubt.
Yes.
And finally, you understand that you are also giving up the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
As to indictment number 24. We good? Okay. As to indictment number 24SC 004749, how do you plead to the charge of child molestation?
Guilty under offer.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at the trial?
Yes.
Are you asking the court to accept your plea as guilty under offer?
Yes.
Is this guilty under offer plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And Your Honor, just for the record, the offered plea is not a part of any agreement. We're just referring to your discretion.
Seems like you're doing a lot of deferring in this one.
I am, Your Honor.
Got it.
Thank you so much.
Oh, sure.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in the official code of Georgia, annotated section 5-6-35, and your attorney can speak more about that. Do you understand?
Yes.
Judge McBurney can fill you in on issues regarding withdrawing this plea. Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness or constitutionality of this guilty plea?
I do now.
Do you understand that the appeals and documents that we have just discussed must be filed by your attorney unless you are representing yourself?
Yes.
Do you understand that unless your attorney is substituted or permitted to withdraw, your current attorney will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes.
Mr. Okoro, that concludes all of the information and questions that I have for you. I'm now going to turn to providing a factual basis for the plea. And Your Honor, I would like to place on the record that we do have 3 witnesses who would like to speak to you at the appropriate time. The location of the offense was at the Grand Hyatt Hotel located at 3300 Peachtree Road, Northeast, Atlanta, Georgia, 30305. That is located within the bounds of Fulton County. The dates of the offense are between March 8th, 2019 to March 9th, 2019. The victim is Catalina C.A.T.A.L.I.N.A. Amaya. AMAYA. Your Honor, had this matter proceeded to trial, the case, the state would have expected to prove beyond a reasonable doubt that on October the 21st, 2021, the Atlanta Police Department received a sexual assault police report from an out of jurisdiction police department. In that police report, it stated that the victim, Catalina Amaya, was in Atlanta from March 8th through March 10th, 2019. She and her family came to Atlanta because her younger sister had a gymnastic competition in Atlanta, Georgia. While they were in Atlanta, they stayed in the Grand Hyatt Hotel. Catalina told Officer Churaman, Churaman, that on March 8th, 2019, around 10 p.m., she and her younger sister were alone in the hotel room trying to sleep. Catalina stated that her cousin, Victor Okoro, came into the hotel room and began to crawl on his hands and knees on the floor towards her side of the bed. Catalina stated that once Victor got to her side, he began to caress her breast. Catalina said that he pulled down her pants but did not touch her vaginal area because he discovered that she was on her cycle. Catalina advised that Victor then made his way to her sister's side of the bed. Catalina stated that she rolled over on top of her sister to prevent Victor from touching her sister. Investigator Copeland, Copeland, reached out to Catalina to ask a few questions and was able to confirm the incident location. Investigator Copeland then asked Catalina if she made an outcry to anyone. She replied that she told her mom about 3 days later. When asked why there was a delay in reporting the incident to the police, she answered that her mom persuaded her not to report the incident. Your Honor, I will yield regarding criminal history, but all the documents that I have reviewed revealed that defendant has no felony criminal history. That just leaves the three witnesses.
Okay, we'll cover that at sentencing anyway, whether there's a criminal history or not. If you could, I'm happy to hear from each person. They should sit where Mr. Peoples is sitting when they're ready, one at a time. And if you just let me know who they are, we're ready.
I will do that, Your Honor. Your Honor, first, I would like for Natalie Baena to step forward.
Judge, would you like us to stay here or sit at the table?
Stay right where you are, please.
And to spell her name, well,
She can do that. Good morning.
Hi.
Hi. Can you spell your name for the court reporter, please?
Yes, my name is Natalie Baena, Nathaly, B for boy, A-E-N-A.
B-A.
E-N-A.
Got it. Thank you for being here.
Thank you.
If you could start by telling me how you are related, if at all, to Catalina and to Mr. Okoro. And then I would like to hear what's on your mind and your heart.
Thank you for giving me the chance to be here to talk to you. Catalina is my younger cousin and Victor is my older cousin.
Okay. I'm ready.
Okay, I guess I'll just get straight to it. I'm gonna get straight to the abuse. It was the morning of my 15th birthday. I was sleeping with my sister at my aunt's house. She was next to me. I remember seeing Victor and his nephew, George, walk into the bedroom, but I was still sleeping. I was just tired. I didn't feel like waking up. I thought they were just gonna walk in. And he sits on the edge of the bed.
He meaning his
Victor.
Victor.
Victor's on the edge of the bed and he slips his hand under the covers, under my shorts, and he proceeds to insert one finger into my vagina. And then he went on to insert a second finger and a third finger. And he tried to do a fourth finger. And I remember that because it was extremely painful. I felt like I was gonna break. I really couldn't handle the pressure at that point. So I had to move. My body reacted to it. I got out of bed and I knew he would follow and he did. I was very nervous that he was gonna stay behind to do something to my sister. So I made sure that when I got off the bed, he followed. And
Your sister was younger or older?
my younger sister.
Younger sister.
Yes.
You were 15. It was your
I was
15th
15,
birthday.
and I know I was 15 because later that day, my parents surprised me with a quinceañera party. It's kind of like a sweet 16, but we're.
I've heard about it.
Yes. And I just remember that day being so significant. Throughout that day, I was dressed up in a dress, tiara. It was a big surprise. My family were all together. He was there as well. And I just felt like I was floating. It was unreal. I was suffering a lot of pain. It was just very dark.
And I didn't mean to cut you off. I needed to understand the relative age of your sister. But you said you got up with the hope that Mr. Okoro would follow you out of the room and not be left alone with your sister.
Yes.
So what happened?
I don't remember much after that. I do know that he followed me out.
Okay.
And I think he went into the restroom with me. The whole purpose was very sneaky. He wasn't supposed to be there that day. I don't know how he showed up. But I know that he eventually left because my sister was left alone. She was sleeping and she was there.
Okay.
In bed. There was no conversation. Later that day, the night at my birthday party, I was by myself in the backyard and I sat on a picnic table. And I remember that he walked over to me and he said, "Do you like that?" And I replied, "No." And he said, "I should have used my tongue." And I walked away immediately after that. It was so uncomfortable. I was so nervous that something might happen after that. I also want to add that a few days after, my parents gifted me a cruise vacation in Miami. And this day is very significant to me because when I woke up the morning, I had peed on myself. And I never peed on myself. I'm grown. I'm 15 years old. I'm 15, so I don't wet the bed. I just know that I was just recovering a lot from the pain that I endured when he started to use his word, but basically fingered me with multiple fingers at the same time. And I've never experienced any sexual relationship with anyone when I was that young, when I was 15.
How long ago was this?
I'm 33 years old.
Okay.
So I think it was.
So 18 years ago.
Yes.
Okay.
Yes, Judge
Got it.
McBurney. It was on my 5th. It could have been August 20th. That's my birthday, but I can't really tell you if my birthday party was on that day. I just know that my
Thereabouts.
Yes, sir.
Sure. Okay. Well, I appreciate you sharing this. Not that you had to go through it, but it's helpful context. In this setting, you're having to talk about it a little bit less than if we had to go through the whole hearing and you'd be asked questions by all the lawyers, but you still had to discuss something painful and personal, and I'm sorry that you went through that. I hope you're doing better. You don't forget. I don't expect you to forget.
Absolutely not, no.
But I hope that you have, since that time, been able to enter into a healthy relationship with someone important in your life, and that you're in a good space. How far did you come to get here? What state are you living in now?
I'm in New York.
New York?
Yes.
Okay, well, good for you.
Thank you. I just moved to New Jersey, but yes, that was just a month ago, but.
Got it. All right. Well, I appreciate you being here. I know it wasn't easy to get here, and letting me know what you went through. It's important to hear that. Do you have any thoughts as to how this case ought to resolve?
I'm sorry, can you just rephrase that question?
Sure. So Mr. Okoro is pleading guilty today, but we're not doing the sentencing today. We'll do that at a later date. You'll be given the date and time of it. If you want to be here in person, you can appear via Zoom. You won't need to say anything again because we're doing that right now. And the state has decided to leave sentencing to my discretion. Typically, the state will say, here's our recommendation, and it will be whatever it is. And I usually ask people who have been directly impacted by the defendant what they think ought to happen. And sometimes they say, whatever the state says, or it should be more, or it should be less. I forgive my cousin, whatever it is. But here the state is stepping back from making a recommendation. They're not required to make one. And in this situation, they're not. And so I'm just curious if you have thoughts about how it ought to resolve in the end.
I appreciate you asking me that. I know for a fact that if I did not come here to support Catalina, because this is my truth, that he would have done this again. I mean, he's been doing it for years and never got caught. Catalina was the bravest one to really speak up, and she really did give me the bravery to also speak up. So I know that he was not going to stop. I fear that he will leave the United States of America. I know that he loves to go to Colombia often. He has some business going on out over there. I assume, just from family talk, I don't really speak to anyone on my dad's side. He's related to me by my father. I'm also very nervous about him coming to New York. He knows where my parents live. And from the past encounters, he always shows up uninvited to family members' home. So there is a fear factor, a little bit of him. I don't know how upset he is right now. I don't think he ever expected me to speak up today. So there's always that fear. I am in a much better place today, Judge. I've gotten enough help, physical therapy, pelvic floor therapy, and I am in a great relationship, someone that loves me dearly.
Good.
I really appreciate it. I think that's my only thoughts on
Okay.
on him. I don't speak to him. But
Good. That's probably the right way to handle that.
Yeah.
Okay. Well, Ms. Baena, I appreciate you being here and sharing what you shared. It was important to hear that.
Thank you so much.
You bet. Good luck with things.
Thank you.
All right.
Have a good one. Thank you. Okay.
Your Honor, next, I would like to have Valentina Del Carmen speak.
Hey, good afternoon. Thank you for being here. I'm Judge McBurney. Same initial question as with Natalie, which is, could you please spell your name and then tell me how you are connected to both Catalina and Mr. Okoro?
Sure. Thank you for having me.
Sure, and you're gonna have to speak a little louder so the court reporter can hear you. Make sure that microphone is down near you. Thank
Better?
you. Yep.
My name is Valentina Del Carmen Baena. Last name is B as in Bravo, Aena. Catalina is my younger cousin and Victor is my older cousin.
So you are sisters with Natalie?
No, I'm their older cousin.
You're there?
I'm the oldest of the three of us.
Yeah, so you're a sister.
No, I'm a cousin.
A cousin. Oh, okay. Lots of cousins. Got it.
So many.
Okay. I'm ready. Tell me what you want to share. Or you don't necessarily want to, but what you feel like you need to share.
My memories of things are not as vivid as my other cousins. The memories that I have they're always in flashes. They're always blurs and like flashing back when you see a movie and things just kind of come in blurs. I always remember just moments with Victor, like in confined spaces, in red lights, in just being alone in a very tight space with him. And like a feeling of sneaking around and just fear that I would get in trouble more than anything else, that I would get in trouble, that my father would just kill me if he were to find out. The things that I remember very clearly are the times that he almost got caught or the times that it didn't happen. I remember once visiting my cousins. I was in New York and he just showed up as he did. He was never really invited. He just kind of would pop up. You'd wake up and he'd be there in the morning, or he'd just come late at night. That was how he always kind of showed up. And I remember I was visiting them. He showed up, they made us sleep on the floor, he got the room, and I remember him coming and trying to wake me. I feel like there was some sort of a, we'll go to the bathroom when everyone's asleep conversation. I remember him trying so hard to wake me up, and I remember just feeling so embarrassed that my cousins were gonna find out that this was happening, right? That he was doing these things to me.
About how old would you have been at these memories you're having? Are you 6,
I believe
16?
that I think I was visiting them for my 16th birthday.
Okay.
And I think this was one of the last times that anything happened
Mhm.
with Victor. I remember him trying so hard to wake me up, and I remember just trying so hard to pretend to stay asleep enough that he would leave me alone. And another time he showed up again, and my father actually had a guest staying with us, a friend of his who had been put in my room, and I was sleeping in my parents' room. And I just remember at like 3 a.m, this insane commotion, and it was my dad's friend yelling at my dad, like, "Do you not see what's happening? Do you not see that he just tried to get into Val's room, into the, like La Niña's room?" And it was because Victor had showed up unannounced. He knew where my room was, and he went into my room in the middle of the night, not knowing that I wasn't there, but my father's guest was there, and trying to sneak into that room to find a man who woke up and made a commotion about it.
Right, big surprise.
Big surprise, big
Yeah.
loud commotion in the middle of the night. So the things that I remember with Victor that are very clear are those. As far as abuse, it's just in flashes. I just remember a red light, his penis in my face, blurs, whispers, and just like a feeling of just shame and fear around everything.
I appreciate you sharing that. In some ways, I guess I'm glad the memories are that indistinct, but there's still certainly things that burdens that you bear. I hope that as time has passed, you've had a chance to get some care in that area and that you're doing a little better now. But I'm now hearing a pattern amongst all the female cousins. I'm sorry that happened. Are you in New York these days?
No, I live in Miami.
Miami. All right. So we're getting from the north and the south. Well, I appreciate you taking time to be here and sharing what you're sharing. Do you have any thoughts about how the case ought to resolve?
I just don't want him to be able to go to Colombia and flee and just disappear.
Okay.
I know one of the most outspoken people on his side has been my father. And I just know that my father would help him disappear and live a really great life over there.
Yeah.
I don't want that.
Okay. You haven't been contacted by Mr. Okoro anytime recently?
No.
He's been out of your life since age 16-ish, or?
I think maybe the last time I saw him was in my mid-20s. I went to go pick up my father, and he came out to the car.
Okay. But it was that tangential. It's not that he's popped up in your life.
No.
Okay, good. Anything else? No, thank you.
Thank you.
Your Honor, I would like for Ms. Stephanie Maina to speak.
Thank you.
Good afternoon.
Hi, Your Honor.
Hi, thank you for being here.
Thank you.
Baina is spelled the same as your cousin's?
Yes, sir.
Okay. Well, what would you like to share?
Sure. Thank you so much for allowing us to speak today. We've been trying to do this a couple times, and needless to say, it doesn't get easier every time it gets prolonged, but I'm very happy to finally say the truth. I'll pick up from where I think it began in terms of the morning that my sister described, the day of her quinceañera. That was in Orlando. I took a nap with my sister because she had a big party.
So you're Natalie's sister?
Yes.
Are you the younger sister that she mentioned?
Yes, I'm the youngest from Valentina and Natalie. I'm the younger sister that was in bed with her.
Okay, so when she, meaning Natalie, got out of the room and wanted Mr. Okoro to go with her. You are the sister she's talking about who was in bed?
Yes.
Okay, all right.
That's me. I went to take a nap with her. I think my parents must have gone to set up this party because we were left at my aunt's house. We were always encouraged to stay together. I woke up from that nap feeling, Victor has a nephew named George. When they came into the room together, I guess George stayed behind, and I believe that Victor was showing George what to do because I woke up to George. I'm sorry for the vulgar language, but I'm just gonna say the way I know, to humping me, to groping my breast, like had his hand under my bra. And I remember I was laying on my fetal position, like on the side, and I was clenching really tight my thighs so that, because he was trying to pull my pants down. I remember it being really a lot of energy because George was my age at the time. I now know that he was probably trying to do what he saw and was trying really hard to accomplish that goal. I didn't know when I woke up, I stayed paralyzed. I just wanted it to stop. My baby cousin was sleeping in the crib in the same room. Ironically, that is the same sister that Catalina's sister.
Oh.
She was a baby. She was an infant. Her cry made my aunt come into the room. I remember waking up and just thinking, where is my sister? Like, why is my sister not in this room? That incident went on for many years. We just didn't talk about it until one day my sister asked me a question on the subway in New York on our way to high school. And she just very straight up asked me, have you ever been touched, molested, or someone touched you when you didn't want it? I then told her about George. She then confided in me about Victor. From that moment forward, it all kind of like made sense for us to protect each other. And so obviously I was very young. I'm the youngest. I must have been 11 or 12 at that time of my sister's quinceañera. And so after she told me about it, there was many times where he would try to do visitations at the house. Obviously, we were a little older now. Like my sister's now maybe 17, now 14, turning 15. We kind of had a little bit more of a right to say, no, we don't want to be home. And so we just wouldn't come home for dinner. We'd stay and we'd walk around the neighborhood, the block. We'd get in trouble, but we just didn't want to go home. And
Be
then,
there when he's there.
right. And then ironically, those are the nights that he wouldn't sleep over. He would send himself home or whatever. But I remember when we were younger, he would sleep over. I remember, I'm sorry if I'm all over the place. I'm just trying to tell you all my memories. On one specific day, Victor came over. When he would come home to visit, it was like a big deal for the family because he is military for our family. That's a big accomplishment coming from first generation immigrant household. So he would be hosted. And I remember my sister pretended to be on her period. And she was on her, we had bunk beds. And so she was on the bunk bed, under the covers. And I remember we were like, we got this, like, we're not gonna let him touch you. And I was staying in the room with him. And I was on the computer and I was Googling things. And I guess I was Googling ovulation. And he comes into the room for whatever reason. And as soon as he comes in, I'm obviously alerted because I'm like, okay, my sister, you know? He's like, reaches over me, like as I'm sitting right now, reaches over me and like clicks on my tabs. And he's like, oh, you're Googling ovulation. That's good. That means you're almost ready. And then went over to my sister and try like whisper into her while she was in bed. And I remember jumping into bed with her and just kind of like staring, not just, I don't know what I was expecting to do, but I was trying to defend her. I just wanted to add that because I am the youngest, I do think that my cousin and sister were able to protect me. from it because I'm older now and like I see it and I'm like, I know that it would have happened to me too if I would have stuck around with family activities or just because I really wanted to protect my sister from it, that I was almost just like, okay, well, it happened to her, happened to her. Like, obviously, like, let me just like woman up and like next, you know? But thankfully, my sister and my cousin, we kind of joined teams and we were like, all right, we can't tell our parents because he's a scary guy, he's aggressive, he has combat training and he knows where everyone lives. And so we just kind of stopped hanging around because we were of age. We were just known a little bit rebellious now because of it. Sorry.
Don't apologize.
Yeah. I can say more, but I can go all over the charts in terms of like,
It's very helpful for you to illustrate what life was like for you and your sister and your cousin, and it sounds like several others. I mean, at the time you went through what you did, was it Gregory, would you say? George, and your sister went through what she did. And Catalina would have been so
tiny.
right. And then we fast forward 10 years and then there's this situation. So
Which is why when Catalina, you know, we were just hanging out as cousins, reuniting. I live in Chicago now. So when we met up one day, because she was in New York, we're like, yeah, let's go grab sushi. And she shared with us, we couldn't believe that like he's still doing it because he is a generation older than us. And so to hear from Catalina, who is in our mind, a generation under, there was a lot of guilt there for not being able to, you know, speak up. So obviously it was an easy decision to come and finally just.
I don't know about easy, but it was an important decision.
Better words.
And you made no wrong choices in this situation. You were put in a scenario that no one should be, and it's not easy to think about it or talk about it. And I'm grateful that you have your sister and your cousins, and that you've become a family network of support. That's very important. Do you have any thoughts about how this case ought to resolve in the end?
Yeah. To begin, I think that I know that he did not believe we were going to show up, I think. And so now that we did and he gets to hear this, I am afraid for the safety of my parents. They live in the same apartment. He knows that. Obviously, Valentina's father supports him. He's been very vocal about it. That's scary because he knows where her mom lives. I'm a mom to a 2-year-old.
Congratulations.
Thank you. And I see life so different now. And I just want to, I would like to show my son by action and not by words that there are people that can help, that will help you if you just ask. And so, I'm sorry.
You need to stop apologizing. Thank you, Ms. Nix.
Yeah, I would like to show him that there are people that will help you and will believe you. And I also want him to understand the dangers. And I've learned a lot from this, but I feel that I don't think he has. I think that he has been having things his way for a very long time. That's none of my business. I believe in God. And so I know that that's above me, but I do think that he's lived a very easy life up to now. And I've personally seen the impact it's had on my sister, my cousin, and me just growing up having to hear like, he's just a very vulgar man. So I had to grow up thinking a lot of things were normal, and I've had to really work on myself to understand now that I'm around 9-year-olds. Like my fiance has a younger brother, he's 9, and I'm around him, I'm like, my gosh, like I would never behave in those manners in front of a child. So yeah, I just would like for you to consider that he's bad and he did what he wanted and he knew what he was doing and he just didn't care. He just thought he would never get caught because he had people supporting him, backing it and hiding it. There's been other people that we know about that are just not here today.
Okay. Well, I appreciate you coming from Chicago. We have Miami, Chicago, and New York. It was important to have you here. And I'm glad you are in a healthier, happier place with you're a mom and you're about to get married. Those are welcome changes in your life.
Thank you so much.
You're very welcome. All right. Mr. Okoro, I need to ask you a few questions. Again, we're not doing the sentencing today, but Ms. Kim, was there anything you wanted to cover? Now's not the time. I know there's, let's hear about Mr. Okoro and that will come. That's not today. But was there anything you wanted to cover?
No, Judge, we'll address it in sentencing if that's okay.
Okay. Mr. Okoro, I do find that there's a factual basis for your plea based on the state's recitation of what it would have demonstrated at trial, not concerning the three young ladies from whom I just heard, but concerning Catalina's situation. I also find that your plea is knowing and voluntary. It's an offered plea. I heard that. You're saying you disagree with what the state has represented the evidence would be, but if the jury heard from Catalina, and they likely would hear from at least Natalie at trial, and hold on one second, people keep hopping on here for some reason. A couple others, a jury could find you guilty. If they did, then we'd get to sentencing in a very different format. I also find that your plea is knowing and voluntary. Knowing means you've understood the things that Ms. Williams asked you about and shared with you and the things I've been talking about. Is that a fair statement?
Yes, sir.
Okay. And voluntary simply means that after you've had a chance to think about this a great deal and be advised by two different attorneys, you've decided that entering a plea, an offered plea, is the right path forward. Is that correct?
Yes, sir.
Okay. Tell me about your immigration status. You're not born in the U.S. What is your status here?
I'm a legal resident.
Okay. Are you native of Colombia?
Yes,
Got it. How long have you lived in the U.S.?
since I was 5.
Okay. It's a long time. So your time in the military was with the U.S. military, not the Colombian military?
Correct, sir.
What branch did you serve in?
The Marine Corps,
For how long?
20 years.
Okay. Ms. Kim, do you authorize someone in my office to sign the indictment indicating Mr. Okoro's offered plea to sign on your behalf as well as your client's behalf?
Yes, sir.
We'll do that. Ms. Williams, can someone sign for you?
Yes, Judge.
All right. Mr. Okoro, a couple of things before I formally accept the plea and then we figure out, we'll actually work with your lawyers and Ms. Williams as to when you need to be back here. You understand, you've already answered this, but I need to have the same exchange. When I sentence you, you'll be required to register on the sex offender registry. Do you understand that?
Yes, sir.
That will limit the kind of work you do. Can't be a school teacher. It'll also limit where you can live. You can't live within 1,000 feet of certain things like a park or a community pool or a church. You understand that?
Yes, sir.
Do you have any idea if your current residence qualifies? It's okay if you don't. I mean, it's as the crow flies too. It's hard to know if a park is 1,000 feet away from your house, but you would also know, hey, look, I live in Chattahoochee Hills and there's no park within 10 miles of me, but there's something you may want to start exploring. Secondly, there may well be immigration impacts on you or residency impacts, removal impacts based on this plea. The way Ms. Williams put it, it was an assertion. You would be removed from the United States, and that could well be the outcome. The most important thing is for you to understand is that there could be adverse impacts on your ability to stay in the United States by going forward with this plea. None of us in this room is an immigration law expert, but the nature of the offense is the kind of offense that typically prompts immigration authorities to seek to remove the person who gets that conviction. Do you understand that that is a very possible consequence of your plea?
Yes.
Okay. Understanding all those things, it's still your preference to go forward with the offered plea rather than going to trial.
Yes, sir.
Okay, then I will accept your plea and find you guilty of the one count in the indictment. Your lawyers, Ms. Kim and Mr. King, will let you know when you need to be here for sentencing. At that time, you'll be able to share with me anything you want to. You have an absolute right to be heard, and you may have others who can speak on your behalf. That's not a requirement, but you and your lawyers may decide that that's something that you want to have happen. Between now and then, you remain on bond and need to comply with all those conditions of bond. You should know that if you absent yourself from the sentencing hearing, I will go forward and sentence you. But if you decide you're not going to appear, that doesn't prevent me from sentencing you now that I have accepted your guilty plea.
I understand.
Okay. Ms. Williams, anything else from the state?
Your Honor, would it be possible to add any conditions to secure Mr. Okoro's return for sentencing?
What do you have in mind?
Perhaps an ankle monitor?
Mr. Okoro, I don't need your street address, but where do you live now?
Albany, Georgia.
Albany, Georgia. Okay. And you've come to every court date that we've had?
Yes, sir.
Okay. You've made that long trek. All right. I will take that under advisement to figure out what we could do on that front. Anything, Ms. Kim, on behalf of Mr. Okoro?
We would ask that if he could just remain as current. He has shown up every single time. His wife has been here. His extended family has shown up as well. I mean, he takes this very seriously. He's already pled guilty. He knows that you could very well sentence him in absentia, but he could also suffer a worse circumstance than if he doesn't appear. So I 100% believe he will show up. He has been on top of this. Every single call I've made, he's always responded. He has gotten away from his job. He's working. He owns his home. His wife is present again. I don't think he would not appear.
I'm not as certain as you are, but the track record Mr. Okoro has had, if he wanted to go to Colombia, he could have done that anytime in the last 2 years. And his case has been as serious day one as it is now. It's a little more real, given the fact that he has entered the plea and I've accepted it. But we will see him on the sentencing date, which will be set by Ms. Nelson. So like I said, I'm keeping the case and we'll coordinate with Ms. Williams's schedule, and you'll need to coordinate with Ms. Amaya's schedule if she wants to be here in person. She's also welcome to appear via Zoom. You'll sort that out. The Zoom, I think, will make it more flexible, but if she wants to be here in person, then we just need it to be a day that works for her, and Mr. King needs to be stateside for it. So we'll work with his schedule. It would help if he filed leaves. We would have a better sense of when he's going to be around. But
Judge, can we work it so maybe it's within 30 days because he has to clear it with his job and he needs to give them notice ahead of time that I've got to be out of work?
So
Lose his job?
I'd like it to be as soon as possible, but we need to figure out everyone's schedule. Okay?
Thank you, Judge. Maybe you.
Yes.
Thank you.
And that concludes my business.
Yes, ma'am. Thank you for being here.
Judge, I wish you luck in family court.
Yes.
Thanks.
Your Honor, that concludes my business.
Yes, sir.
Thank you.
Thanks for your help today.
Yeah. Judge, I think that's all that matters for me on this topic.
Boy, the exodus. Yes. Yes, sir. You are.
Deal again. Falsified document. Sir.
Oh my God.
Falsified document of the probation that you can send you to prison, that were left in your homes. I had a new report, and they want to know that, since you didn't sit in prison, can you have something on writing and notified that you didn't sit in prison? That you did not, that I did not come to your courtroom, that you did not see me on April 28th, and that you did not see me in prison.
So tell me your case number.
My case number.
Is all that we have left Mr. Smith's plea? Think, okay. We'll do that in a second. I want to get this case number. And gosh, it's 1:10. Quite the day. You guys are good to go unless there's something you wanted to talk about.
Should we go on the record whenever?
Sure, we'll finish with Mr. Dill and then we'll get on the record. We need to get on the record.
Case number 15SC135749.
All right, give me 1 second. So hold on. Why is it that you think this case I have, you had Judge Richardson and originally Judge Goger, isn't it?
This is April the 28th, 2021. Got your name on it when I never entered your courtroom and you had never sent it to me, but I ended up in prison and they released me saying that you sent me the document, also by a document with your signature on it.
Okay, hold on. I see there's a probation revocation order here.
Never been revocated for that case.
Okay, yep, so I did on the 28th, so you must have been in one of the accountability courts, because it was Officer Malud. Drug court, yeah.
Never in drug court, this is what I'm trying to say. I was never in drug court, I got locked up at the hotel. When I got locked up at the hotel, I came to Fulton County. You remember I seen you one time, and I was telling you, my probation officer signed me up to this AI technology program for the military. And when I told you before the notice, you say, I'm gonna check into this Q-wave of technology. When I told you before the notice, the next thing I know, 2 weeks later, they told me to pack it up. I said, well, I'm going, I gotta go to Judge McBurney. They say, no, Mr. D, you're going on the road. You ain't gonna talk to Judge McBurney. I said, I've been talking to Judge McBurney about the probation, about my case. They told me, pack it up, Mr. D, you getting up out of jail. They took me, Fulton County officers took me from Fulton County, took me down to a prison. I didn't even go to do diagnostics, and they told me they told me they was told to drop me off right here. When I went to a camp, I went to this prison, so they were like, "How you get down here?" I said, "Fulton County Sheriff's brought me down here." They're like, "You ain't got no paperwork. How you get down here?" I said, "I ain't got no paperwork." So when I went to the ITM program, they say, "Well, we have a paperwork with Judge McBurney there." I say, "Well, I didn't go to Judge McBurney to get sentenced," and they were like, "Well, we don't even have no transcript. So where's your transcript?" So I was like, I don't have no transcript. I didn't even go to diagnostics. So they shipped me out to another prison in Johnson State Prison. So when I went to Johnson State Prison said, "How you get down here?" I said, "Well, Fulton County Sheriff dropped me off at the Fulton County Sheriff dropped me off at the ITM program."
So tell me what it is I'm piecing this together. You were in drug court, Judge Dempsey terminated, just hold on. You were in drug court, Judge Dempsey terminated you from drug court. I've seen that. You had a revocation to go to RSAT. I don't know if that didn't happen, but then ultimately you ended up in front of me and we said not RSAT, but ITF.
I never go. We never sentenced me.
So it's not a sentence, it's a revocation. But tell me what you need now, because you're clearly not there anymore. You're here.
Because they left me homeless because I didn't enter your court on April 28, 2021. You can check your camera any day because there's no transcript.
Okay, tell me what you're looking for today.
Because I reported to the news station about government corruption with my probation officer. So the news reporter want to know if you didn't go to Judge McBurney to get sentenced and then throw you up, that is government corruption. Can you get him to say that he didn't sign anything and he did not send me to prison on April 28th?
Got it.
Yes, sir, and I didn't need that notarized so I can give it to the news reporter, so I can get that probation officer probation for violating my life and ruining my life when I'm trying to live a crime-free life. I ain't been in trouble. I tried, no, say I ain't got no drug charges, and this probation officer just ruined my life, and I just want to.
Understood. Looks like your termination was probated. I mean, your probation was terminated in April this year. You got put into the competency docket and Judge Ingram closed all that out. So you're good to go with probation. So I'm wondering why you don't want to just put this behind you.
Because it left me homeless and it ruined my life, and she did something illegal.
Who's the she? The probation officer?
Cynthia Johnson was the former chief of probation at 276. She signed me up to a technology program. Look at the back of my head. I went to the doctor.
Right, the Q-Wave.
Q-Wave technology.
Okay.
Artificial intelligence. And she controls humans like robots with the military.
All right, do you have a document you'd like me to review, or do you want me to create a document?
I want you to create a document saying that I did not come to your courtroom on April 28th and you did not send me to prison. And I can get it to the news reporter to set up me a GoFundMe account so I can find me somewhere to go, but it left me homeless.
Got it, the GoFundMe account. So here's what I'll do. I did sentence you, so I can't say I didn't. That would be untrue. But I'm gonna take you up on your request, which is to see if we can review some video footage or something that would show that, or a production log that showed you were transported from the jail to here on that day in April.
I didn't come to your courtroom, you didn't sentence me on April 28th. Remember, I came back the first time you said you did not sign it. I got a falsified document that I did not come here. I'm pretty sure.
Okay, you don't need to show me anything. I'm looking at what's in the docket, and I did sign that order that sent you to ITF, and I signed that on the 28th of April.
You know what I'm saying? But I didn't come to court. So how can I sign something that I can defend myself or come to court?
Well, that's what we need to figure out is, did you come to court or not? So I'm gonna look into that. I'm hearing your words. I need to verify that.
I was at Fulton County Jail. I had never seen you on April 28th.
Okay.
When you pull my name out, when you see my name, I'm at the Fulton County Jail. That's why I was confused about them sending me to prison, because for revocation, I got to be present for the revocation to explain why I didn't go to probation.
Right.
Am I correct?
But it could well be that we did it over the Zoom calendar or who knows what.
We did that, sir.
Okay, well,
You didn't even have a transcript for
I'm gonna look into it and I'll let you know. Okay.
Because I didn't go to court, so I know you ain't signed that because you ain't got no transcript.
Okay. I'm hearing you. All right, well, let me look into that and you know how to find me.
Yes, sir. So, can you give me time to come back?
Yeah, give me a couple weeks so we can figure out what we can about the calendar, okay?
Okay, so can I let you know my life, my situation with the AI is a life and death situation.
Well, hang in there for 2 more weeks, okay? And come back here.
You know, technology killing.
I got my fingers crossed you're gonna make it till 2 weeks from now, all right? Stay out of the heat. All right, Mr. Wooten and Mr. Ford.
Judge, I think where we're at is I think both sides are asking if the court would just proceed with the motion today.
The motion
The motion that we had filed, I guess, last week to go ahead and proceed with resentencing or consider resentencing and then proceed in absentia if the defendant did not make herself available for court, which it appears she hasn't. And I can make some additional representations if the court wanted me to, but I think both sides are asking to just go ahead and resolve this today.
Okay, we could do that. We're gonna take that other plea first because that was on the calendar. All I was gonna do today in the FYI category was take Ms. Brown into custody. And then we would do whatever resentencing or sentencing looked like at a later date. But she's not here. she is very arrestable. I'm a little confused as to how that hasn't happened yet. I don't think her location is a mystery, but the people have lots of priorities, and taking her into custody is not one of them, apparently.
And I can say part of the judge is that we've reached out to Paulding County and they, I guess, can't prioritize the arrest unless they have a sentencing order that shows that she's a convicted felon. That's what I don't know all the details, but
Okay.
her status as a convicted felon, my understanding is what.
Would move it up the list. Okay, well, that may be what we need to do. But what I'd like to do then is handle this scheduled plea. And then we can think about whether we're gonna do the sentence modification. I'm very open to the concept. I don't know that I'm open to the timing, but we'll figure that out. All right, if we could please bring Mr. Smith out. Hi.
Hello. You'll catch.
Okay. Yes, number 8.
And Your Honor, I appreciate you taking this before we're taking a break.
Well, I'm gonna take a break after we take this plea. Chat with a few people here and get them on their way and see. Oh, Mr. Smith.
Hello.
Hey. All right. Ms. Watson, you still with us? I know it's been a long morning. And I assume you would have clamored if you needed a break.
Yeah, I'm good still.
Okay, good. So this is position 8 on our revocation calendar, State versus Thomas Smith, 25 SC 006-526. Mr. Smith, you're charged with 1 count of aggravated stalking. You and I have had a number of conversations about options, one of which was accountability courts. This was when Ms. Kim, I think, was one of the lawyers in the mix. But we're gonna, I think, go forward with a plea now. Is that your understanding?
Yes, sir.
Okay. Counsel, if you could state your name for the court reporter.
Yes, Your Honor. Carlos Mucha, M-U-C-H-A. And I work with Ms. Kim. She's still his counsel as well. My understanding is it's a first offender plea, and then he'll be in accountability court.
Okay. Well, let's work our way through it, see if that's how it plays out. Ms. Nix is going to put you under oath, Mr. Smith, and ask you questions about your case and your rights. Please listen to her carefully and answer carefully. If at any time you've got a question, I need you to let Mr. Mucha or me know that. Will you do that?
Yes, sir.
Okay. Ms. Nix?
Judge, Mr. Smith, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Please state your true, correct, and legal name.
Thomas Clifford Smith.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
No. Well, I didn't get my insulin this morning, but that's it.
Insulin is the only medication you're taking at the jail.
That was what I didn't get this morning.
Got it. There were some medicines you took this morning?
Yes.
And tell me, for what do you take those medicines? What do they help with?
I took 10 milligrams of.
You don't need to name the medicine because those are hard to spell.
Okay.
I need to know for what I take it because I have headaches. I take it because I have a broken wrist.
One is an antidepressant and one is a mood stabilizer.
Okay. And you got both your mood stabilizer and your antidepressant this morning?
Yes, sir.
When you take those, do they make you woozy or drowsy or feel out of sorts?
No.
Thank you.
How old are you, Mr. Smith?
41.
How far have you gone in school?
I have a 4-year degree.
Is English your native or dominant language?
Yes.
Do you understand that you've been charged with the following offense, aggravated stalking?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to this charge?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charge against you at a jury trial?
Yes.
Have you had the opportunity to review your rights with your attorney?
Yes.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes.
Do you need more time to discuss the case with your lawyer, Mr. Mucha?
No.
Are you satisfied with his services?
Yes.
Mr. Mucha, do you waive a formal reading of the indictment for purposes of the plea?
I do, yes.
And do you waive any and all defects in the indictment for purposes of the plea?
I do, yes.
Mr. Smith, do you remember having been arrested on this charge?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, I'm aware of them.
You understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court. State recommends a 5-year sentence with the conditions, probated sentence with the conditions that you complete drug court and have no contact with Marlena Smith.
Yes. Does that mean this is,
Well, they share a child, so there's to co-parenting to.
between, for the period of 5 years or for the period of the no contact order? That's the confusion that I have.
For the period of your,
So it would, well, you go ahead. What are you recommending?
I'm recommending for the period he's on probation that you have no contact with Marlene Smith.
Right, that typically a condition of probation is coextensive. It lasts as long as your probation. If your probation ends early, that condition ends early. But it would be at most 5 years of no contact with Ms. Smith. Now, we may need to define what no contact means. If you have a child together and you are going to engage in co-parenting and you're authorized to engage in co-parenting, either you would need to have contact with Ms. Smith, or we'd need to designate who the third party is who coordinates that, who is the go-between. So you would call Stan Smith, and Stan Smith would call Marlene Smith saying, hey, it's time for Thomas to pick up the boy or a girl.
Girl.
A girl. Going to pick up the daughter at this place at this time. But we'll work through that.
But I guess as long as the probation officer, has the authority that they can designate someone.
No, we would be working through that now. We wouldn't leave it open. So we'll talk about it.
Okay.
Keep going.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes.
I think we're still at final plea posture. Is that right, Judge?
I believe so.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
No.
You understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
You understand that while you're on probation, you must follow all the special conditions of your probation?
Yes.
You understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty or nolo contendere to a felony in the state of Georgia?
No.
Have you ever pled guilty to a felony in any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked?
Yes.
This means that you could be adjudicated guilty and resentenced up to the maximum sentence for each charge in this indictment.
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charge of aggravated stalking in indictment number 25 SC 006526?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal as
Yes.
outlined in OCGA 5-6-35 within 30 days of today?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition, and you only have 4 years from today to do so?
Yes.
Judge, had this case gone to trial, the state would expect the evidence to show that between the days of September 18th and September 24th, 2025, the defendant did contact Marlena Smith, that's Marlena Smith, common spelling, without the consent of Ms. Smith for the purpose of harassing and intimidating Ms. Smith in violation of a temporary protective order which prohibited such behavior by Thomas Smith. And this occurred in Fulton County. The defendant does not have any criminal history and is eligible for first offender.
All right. And have you spoken recently with Ms. Smith or someone in your office?
We have, I spoke with her a few months ago, and she is on board with the defendant going to accountability court. She does want no contact with him and wants him to have no firearms. And I did tell her that that he was eligible for accountability court and that that's what we would offer. That probation has a standard condition of no firearms, and that I would definitely make no contact a condition of his probation.
Did she relay anything about who has custody of the daughter?
The son?
She has custody of the daughter.
Daughter, I'm sorry.
And I do not know if I asked her, I do not have notes about whether they have a visitation order.
Okay. All right. Ms. Smith, man, do you have anything that differs in terms of criminal history? It's sounding like Mr. Smith is eligible for first offender.
He is, Your Honor. There's just 2 prior arrests, not including the one before you, one misdemeanor conviction, 2010 Cherokee County Sheriff's Office DUI. Nothing further, Your Honor.
Okay. Thank you so much for your help today. You are good to go.
Sorry, Judge, one more thing.
Thank
The
you.
daughter was included on the TPO that led to this case.
The daughter was, so it was no contact with mother or daughter.
Correct.
Okay. All right. Mr. Mucha.
It didn't say no. 200 yards.
Oh, yeah, I guess the order said no contact, but not within 200 yards. He's relaying to me what the TPO says.
That's what I have in my notes. I'm pulling up the TPO to confirm.
Right. And there has not been a visitation order issued for custody of the child. So
She has a 1-year temporary custody based on the TPO. But what I was curious about was can I just speak openly?
Please.
Basically, I was,
How old's your daughter?
she's 6 years old.
Okay.
And, you know, I'm not the same person that I was 9 months ago. I've had a lot of time to think about what's important to me. And first I'd like to, I want to take accountability for my actions. I am fully aware of the negative consequences that I have had on my wife and daughter. And, that weighs on me significantly. I have remorse for those, for my actions. And I understand, what I did but I just, I don't understand what's going to happen as far as me getting to see my daughter because she's innocent in all of this. Like,
So the answer is, let events unfold a little bit longer. What I'm going to do, assuming we go forward with the plea, is set some basic conditions to your sentence, and I'm happy to modify them if drug court's going well. You have a 50-50 chance to be in drug court with me. There are 2 drug court judges. It may be you're with me, you could be with Judge Krause. But if you're with Judge Krause, she can let me know how things are going. It is not at all uncommon to have drug court participants, after they get a few months of proven sobriety under their belt and strong performance in drug court, to say, hey, could I address a condition of my sentence? I want to be able to be around my spouse or my child or whatnot. And that's one of those, let's see how you're doing. And that would involve the state reaching out to your wife and saying, hey, things are a little different. Mr. Smith would like to have access to the kid or your daughter. You also have that 1-year clock that is almost over. If it was a year back then, you can see we're in June. And so it will be up soon. And so those are all important subjects to discuss. Today isn't the day we resolve them. In fact, today would be, if we go forward with the plea, would be, all right, next up is getting you into drug court and getting a couple months of good, sober performance in drug court. And then it's natural to say, well, you know what, I'm going to start working again. How do I reintegrate into the life I had? And your wife gets to exercise her decision about whether your life going forward involves her. Your daughter, as long as it's safe and it's in the best interest of the child, and it typically is, because she's 6, she's not 6 months, so you were present in her life for years.
Right.
What would be in her best interest would be to be able to spend time with you, assuming you are functioning and not doing something scary. So you earn that, and you may well earn it quickly through a few months in drug court. But we'll assess that a little bit later. I think it would be premature to say, great, at the 3-month mark, you get 6 hours a weekend with your daughter and then this and that. We're also not the parenting experts in drug court or right here. There'd be someone who would assess what's in the best interest of your daughter. And we would marry that up with how are you doing in drug court. That's the part you control. And if you're doing well there, then you present the best face to that situation. Does that make sense?
Yeah, so basically what I was trying to clarify was that sort of like when the no contact order expires, this stipulation kind of takes over and can be revisited through the ongoing my progress through the drug court and stuff.
Correct. Exactly right.
And finally, I just want to say that I apologize to everyone who was involved in this case. Especially my wife and daughter.
Okay.
And
Well,
I appreciate the chance to redeem myself.
Good. Let's use it wisely.
Thank you.
Anything you want to add? That was pretty well spoken, Mr. Mucha. Anything you want to add?
Only, Your Honor, coming out of into the drug court program, he's been in custody a while. He doesn't have any funds. I would just ask if you could waive probation fees for at least the first few months. And I'd like to seal the arrest record, if not right away, at some point. So when he's seeking employment, the arrest doesn't show on there.
Sure. So a couple things on that front. One, there are no probation supervision fees while he's in drug court. His probation will be on an administrative status. He won't be reporting to probation. There are drug court fees, but those are pay as you are able. And are waivable until people are working.
Do they offer the FVIP? I know that's something that he'll need to go into.
The FVIP, yeah. On the TPO, it said I have to do these family violence intervention program courses, and I believe that you go through kind of like it's like going to a DUI school or something where you pay an agency to do classes. I think.
I'm sorry. I'm stepping in for Ms. Kim. That's through the TPO. That's not a part of the sentence. I thought that the FIP was part of the sentence. I apologize.
I didn't hear Ms. Nix recommend that. So there would be counseling he can get through drug court as well.
Okay.
All right.
All right. Thank you, Your Honor.
You're welcome. Did I say anything wrong about probation, or in fact, the fees are waived as long as he's in drug court? Okay, I didn't make that up. All right, Mr. Smith, I find there's a factual basis for your plea in that your plea is knowing, meaning you've understood what we talked about, and voluntary, no one forced you to plead. I will accept it. I appreciate you are seeming very self-aware right now. That is healthy. I hope you maintain that. Mr. Mucha, can someone in my office sign the indictment on your behalf and your clients?
Yes, Your Honor.
Ms. Nix?
Yes, sir.
All right. Mr. Smith, you qualify as a first offender. I will sentence you as a first offender. It is primarily a benefit. It means that this is not a felony conviction. You will be under sentence. You may not have a firearm while you are under this sentence, but at the end of your sentence, you remain not a convicted felon. That helps with work, if you want to go on to graduate school, et cetera, et cetera. It carries a risk. If you derail 6 months in and you leave drug court and you relapse or something happens, not only will you have new charges, but the state can petition the court to revoke your first offender and resentence you up to the maximum. So you'd have a bunch of years you could be looking at. Not if you jaywalk, but if it involves something where you were threatening towards your wife or something like that, that would be a signal that first offender didn't make sense, that you don't have things under control, and there could be some pretty serious consequences. Do you feel like you understand the risks and benefits of first offender?
Yes, sir. I see the risk reward.
And is it your request to be sentenced as a first offender?
Yes.
Do you need housing? Because we have temporary stable housing through drug court.
Yes, I do. I believe last time, Miss Kim said that I was able to get,
90 days.
well, she said she was able to get, double, like 180 days, like double that.
Well, I wouldn't worry about the numbers yet, but you or someone has told drug court that you need housing?
Yeah.
Okay, they'll take care of that initially. I will sentence you to 5 years to serve 9 months with the balance on probation. Special condition of probation number 1 is that you enter into and successfully complete drug court. It means if you're terminated from drug court, I could revoke all your probation, not a little, but all. And special condition number 2 is that until further order, you will have no contact, direct or indirect, with Ms. Smith. If we need to develop a way for you to spend time with your daughter, we can come up with that third-party conduit. Or it may be, after a few months of drug court, your wife says, you know what, I'm okay having communication solely about visitation. But that'll be her call. What won't be her call is your ability to spend time with your daughter if, in fact, you have legal custody of her as well. And then we would need to develop that third-party transfer, okay? Ms. Nix, anything else on behalf of the state?
No, sir.
Mr. Mucha, on behalf of your client?
No, Your Honor, we think we covered everything.
Okay. Ms. Simpson, does Mr. Smith need to at least report, or he just needs to go to drug court and probation will lift off from there? Okay, there you go. Any questions?
No, Your Honor.
Okay, good luck, Mr. Smith. I may see you in drug court.
All right, thank you.
Thank you.
All right, we're going to take a break. Mr. Ford, Investigator Ansel, if you guys are still wanting to push forward with the Ms. Brown thing, we're going to do that at 2:15 here. But I got a couple things I need to do with a couple people here, and I have an adoption at 2 o'clock. It'll be short. I'll do that back in chambers. You'll be happy, and then I'll sadly see you all again. Okay? So 2:15.
Judge, can we stay in here during that time, or do you need us to?
You can stay right here.
Perfect.
I'm just going to mute things. All right, we are back. Ms. Watson is still here. So tell me what you're envisioning doing. I did the adoption. I have a civil matter that's supposed to start in 10 minutes, but it can wait a little bit. I'm noticing a long list on Zoom, and that's not what we're doing today.
Sure, Judge, what I thought, so we had filed a motion, when was it, on the one day early last week, that was to not, basically to withhold entering a written sentencing order so that the court would be able to modify if the court felt that was the appropriate thing to do. And then a rule NISI was issued that day, setting that motion down for a hearing for today. So I thought we were actually gonna have the hearing on that motion.
Okay, I thought we were just going to encourage Ms. Brown to show up. That was I don't know that I had issued a bench warrant so much as I revoked bond, but now I can issue a bench warrant. I was just trying to create a more complete net out there. But it doesn't mean we can't talk about it, although Mr. Ford would need to make a record of how he's waiving her presence for that, which I'm sure he's capable of doing, but.
I put in that motion, Judge, a paragraph or two about that and found a relevant case. Not the exact same situation, but related to sentencing where a defendant didn't appear. It was a restitution hearing, but the court assumed, I think the language was like, we assume without determining that restitution is a critical proceeding in the prosecution. And so part of why I asked for the rule NISI was because in that case, the Court of Appeals found that the trial court was authorized to proceed in absentia because there was a rule NISI that was issued, defense counsel had been served, defense counsel had notified the client and they just didn't show up.
Yeah.
And so that's how I envisioned it. I think that the court does have the authority to proceed. And given that we're not gonna have Your Honor much longer, I thought it might make sense to just go ahead and get this wrapped up while you're still here with us and not in family court.
Okay, so two things. One, did you file it under the old indictment number? I'm not.
It's under the 25 SC 002906.
That one. Okay, what's the 536? Oh, that's an even older case. Never mind. I had to look her up by name because I didn't have the case number, but now I've got it. Okay.
The second most recent filing and the rule NISI is the most recent.
Yes, I see it. Actually, a subpoena is the most recent.
Yes.
Okay. All right. So that was one. Number two, I'm keeping this case for sentencing purposes, not only for Ms. Brown, but also for her mother. So even though I think it applies to still say McBurney on it, but even if it says Ellerby, Judge Ellerby and I are meeting on Wednesday to talk about the few things I'm holding on to and everything else is going to her. So there's not that pressure, but I'm happy to hear you out if you want us to get on the record.
And I guess really with that pressure not being there, I would still like to proceed just because the victims, we've done this so many times and at some point we've got to just proceed. I think it's the state's position. And then also, like I mentioned before the break, that Paulding County is saying that without a written sentencing order, they can't prioritize it. They've many prioritized it, but they won't. My understanding is they will not bust a door down to get something. Like
I don't need
knock on the door. If the person doesn't answer, they just leave.
Okay.
Without that paperwork.
It's dramatic. All right.
And I should probably make Your Honor and counsel aware, since we were speaking this morning, I've been made aware that Ms. Brown and her family are going to be seeking new counsel. They're dissatisfied with my unwillingness to file a motion to modify relative to her medical condition. And I've tried to explain that due process is predicated upon attendance, and that's fallen on deaf ears.
Okay.
It is my understanding, to the extent that I have been given access to my client, that she is not able to come to court for reasons that have been attempted to be made self-aware by virtue of the email correspondence, the medical records, et cetera. But I have no more additional information for Your Honor or the state as to what her condition is other than what's been presented.
Okay.
So I guess my position would be that her non-attendance is not voluntary, but due to her medical condition, she's bedbound with the conditions that I've provided you. Acute encephalopathy.
Okay, well, let's get on the record in a second. This was all informal, but I want us to get on the record. So you are, Mr. Wooten, more focused on getting a sentencing document in place and less concerned, based on your review of the case law, that it would be a fragile sentencing document because Ms. Brown is not here. As you weigh the different.
I feel that if we proceed today, if Your Honor enters a sentencing order, if she, obtained new counsel and they decided to appeal, I think that it would hold up on appeal.
Okay.
I believe. Now, with her potentially saying she wants new counsel, I don't know where that leaves us. I guess if that's not coming from her.
No, it's not in the docket, so I appreciate the alert, but I would have to excuse Mr. Ford anyway relieve him from those responsibilities, and I didn't hear that happen yet. All right. Ms. Watson, we're going to get on the record. This will be our final matter. I appreciate you sticking with us. And the case number is 25 SC 002906. It's State versus Kayla, Kayla Brown, standard spelling. We have Mr. Wooten here for the state. Mr. Ford is Ms. Brown's attorney of record. Ms. Brown is not here of her own volition. I appreciate that Mr. Ford is going to get on the record in a moment that he thinks that there are some medical or health reasons that prevent Ms. Brown from being here. You can make that record, but I find that Ms. Brown was aware of today's proceedings and was able to be here if that was a priority for her. But I understand that she's made a different decision. And so, Mr. Wooten, I'll start with you. You had filed a motion actually to withhold sentencing, but now I think are ready to press me to enter a written final disposition. So I'd just like to hear what you think the parameters are. You had recommended a 15 to serve 7 balance probated with a whole host of conditions that flowed out of the Lafleur-Fry notice that had been filed, and we would import those, but it was can't be a securities dealer, restitution in significant amounts to all the people that we covered before. So we don't need to revisit that so much as the top line, which would be the duration of the sentence, the portion that is custodial and the portion that is probated.
Judge, the state's recommendation is that it's still that 15 serve 7. I would just note for the record that there was at the initial plea hearing and the initial sentencing hearing discussion of a cap that was agreed to. I still believe, and I think for purposes of making sure that this doesn't come apart on appeal, that the court should stay within that 7-year cap. I think that that Ms. Brown's voluntariness to enter the plea was dependent on that 7-year cap. And so I just asked that the court sentence her to the 15 years to serve 7, balance on probation. I've laid out all the reasons in the written motion, so I don't think I need to rehash those on the record. The only other thing that I would point out is that there was some discussion at the time of sentencing about there was a $20,000 cash bond that was put up in this case for a prior case number. The state's recommendation was that we enter an order under that case number that distributes that restitution at a pro rata basis to all of the victims. When we were here back in, I believe, 2024, when Ms. Brown was first arrested and the state recommended a cash bond, it was for that explicit purpose so that later on it could apply to restitution potentially in the future if she were convicted, and that's where we are now. I know that the court had mentioned when we were here about a month ago the possibility of having that money transferred to the defendant's mother, Ms. Jones. I've spoken with the victims about that. They're very much in opposition to that for reasons that I think speak for themselves. But I am also very much in opposition to that, given not only just the fact that we set up the bond in that way on purpose with that intent in mind, that it be distributed at a later date to the victims. But also just keeping in mind what has brought us here today, that Ms. Jones, Trahella Jones, has come into court, has made representations on behalf of Ms. Brown that I think are not supported by the documentation that we've seen. And I ask that the court take that into consideration, not as punishment to Ms. Jones or Ms. Brown, well.
Or her kids.
Or her kids, but taking into consideration that representations that may have been made to the court, that there are some issues with credibility as it relates to that. And also taking into consideration that at sentencing, Ms. Brown represented that she had $60,000. We haven't seen that, but I think that any concerns that the court may have about the children, there's already supposedly $60,000 set aside. We still think that should go towards restitution too, but the $20,000 was immediately within the court's control. And so we asked that that be distributed to the victims.
And how does one decide how to distribute 20,000 across all of it? I mean, some people will get a nickel.
Sure. So
but that's more than zero.
Sure. And I haven't submitted anything before, but I've kind of in my own work product created a worksheet that divides it up. And the court's correct that some people will get significantly more.
I mean, as they should. I mean, we learned that there are people who are out 5, 6 figures versus 3, 4 figures. And everyone is a victim there. But as long as you've got a mechanism where you would drop through restitution amount and it would push out that you get $42, you get $420, you get $4,200, then I'm okay with that.
And I can submit that to the court. I also think that that doesn't preclude the court from, obviously I'll get that to the court very quickly, but I don't think that precludes the court from entering a sentencing order under this case number, because I think that would just be a separate court order under the prior case number.
Understood. Okay. All right. Mr. Ford, what would you like to get on the record in connection with Ms. Brown?
Thank you. She is currently afflicted with acute encephalopathy as well as conversion disorder per her doctor's report that was here earlier today, and that she is not here due to those medical conditions as opposed to choosing not to come to court. It is my understanding that she has been back and forth and she's now back. She is not in a hospital. She is home, but she's under care, not of a 24-hour nurse. But she does have physical therapy and speech therapy, occupational therapy coming to her home. She has been made aware of today's appearance. I made her aware last week. And it is her position that because of her health condition, that's why she's not physically here, respectively.
Okay. And you've very consistently represented that and done your best to share what's been provided to you, to the state and with me. So I appreciate not being kept in the dark any more than you've been kept in the dark. Where you see a little bit of light, you share that little bit of light with us. Okay. Well, I find that it's appropriate to move forward with a sentence modification hearing, given that Ms. Brown was aware of what's happening. She may be listening in right now. Hello, Ms. Brown. And in light of the changed circumstances and what I'm going to describe as the fraud that never ends, it's appropriate to sentence Ms. Brown slightly differently than I had outlined at the hearing we had a few months back. I need to see the indictment. So, Mr. Wooten, I don't remember the ranges. Your indictment conveniently places the allegations into 5 buckets. There's the RICO violation, theft by taking, securities fraud, insurance fraud, and identity fraud. I just need you to remind me of the sentencing ranges. Ms. Brown is charged in all 35 counts. So it's not going to be a complicated sentence. Well, I shouldn't say that because it'll be a lot of work for Ms. Nelson. But to pronounce, I just need to make sure I'm not pronouncing an illegal sentence because a number is greater than the statutory range for the offenses.
So Judge, the theft by taking counts vary because of the amount, so I'll just go one at a time, but count 1 is 5 to 20 years. Counts 2 and 3 are both 2 to 20 years. Count 4 is 1 to 10 years. Count 5, 2 to 20 years. Counts 6, 7, and 8 are 1 to 10. Count 9 is 1 to 5. Counts 10, 11, and 12 are 1 to 10. Count 13 is 2 to 20. Count 14 is 1 to 10. And then counts 15 through 27, the securities fraud counts are all 1 to 5. Counts 28 through 33, insurance fraud, are all 2 to 10. And then counts 34 and 35, identity fraud, are 1 to 10 years.
All right, got it. So in light of how Ms. Brown and frankly her mother, because that impacts the bond situation, have handled things, I am going to sentence Ms. Brown on count 1 to 15 years to serve 7. Counts 2 and 3 are also 15 years to serve 7. 4 through 8 are all 7 to serve. 9 is 5 to serve. 10 through 14 are 7 to serve. 15 through 27 are 5 to serve. 28 through 35 are 7 to serve. All those run concurrently with each other. So the total sentence is 15 years to serve 7 with a balance on probation. And there are a host of conditions of probation, special conditions of probation, and they are set forth in the state's Loeffler-Frye notice that I think you got to Ms. Nelson in Word format already. That was a project for you after our first sentencing hearing.
I will send it again just to
Please do, and I'll incorporate those. They didn't elicit objections from the defense. The defense focus was understandably on time to serve. Mr. Ford, there had been a little bit of healthy back and forth about, well, is the restitution amount the figure set forth by the state, which I think was just north of 600,000. And you at one point were describing it, I think it was more in the 400s. And I just want to make sure if you are challenging it, which is your right, that either since that time, Mr. Wooten has given you documentation that has caused you grudgingly to say, yes, it is north of 600, or if we need to have a subsequent hearing on that, which wouldn't delay me entering a sentence, we would just hold off on the restitution number. I'm going to start with Mr. Ford on that, then I'll hear from Mr. Wooten.
The attachment that I've seen with restitution amount is 611,000 some change, and
it adds up?
Yes.
Okay.
And Judge, I just add that at the prior sentencing hearing, Ms. Brown did waive her right to a restitution hearing on the record.
Okay, well, that makes it easier too. So that's the figure. We can work through what language would go into what kind of order to deal with the bond and the money that was put up for the bond. But I have, in light of how things have unfolded since our sentencing day, taken a different perspective on what should happen with that money, and that it ought to be the beginning of a long road towards restitution. And so it would pass through that filter, and you can decide whether what I need to do is enter an order that says $11 goes to this person and X, or if it all would go to, I really wouldn't go to the Department of Community Supervision because Ms. Brown won't be on probation for a while. So think through how you want to structure that. It's probably cleanest if the sheriff is dispersing it to the individuals and they show up and say, I'm so-and-so, where's my $50?
I think, Judge, what might be cleanest, and we'll talk to the sheriff's office just to make sure, but is if the sheriff's office remits it to the
Clerk.
clerk.
And it goes into the registry. Yes, yes. The sheriff is 100% going to want that.
Yes.
Structure in order to that effect, obviously run it by, Mr. Ford. But the money is the money. And so, he needs the chance to eyeball it, before you send it to me.
Absolutely.
Anything else, Mr. Wooten, on behalf of the state?
I do not believe so, no, Judge.
Mr. Ford, I appreciate your involvement in this chapter. I suspect there will be a short subchapter in which you may not be involved, but you have done your client far more service than I think she is going to appreciate in a going forward basis. But I appreciate it.
Thank you.
All right. Thank you, everyone.
Thank you, Judge.
Ms. Watson, that is it for criminal today. The remainder of my day is civil stuff, and those lawyers need to provide their own court reporter. So thank you so much for your time and sticking with us.
Thank you. Have a good day, Judge.
You too. Bye-bye. Take care. You're going to actually immediately immolate when you step outside with that much fabric on you. Okay, because it's like 105. It's like, what's that ball of fire outside the courtroom? Can I end this one?